The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Ms. Adjuin, you may proceed.
Thank you, Chief Judge Gregory, and may it please the court. The district court below stated that it was, quote, troubled by what occurred, end quote, in the state court proceedings in this case, noting that they were unusual in many ways. Quincy Allen's capital trial was plagued by a series of significant constitutional errors, beginning with the guilty plea process and continuing throughout the penalty phase. These errors were not redressed in the state court system solely as a result of unreasonable applications of clearly established Supreme Court law and unreasonable factual determinations. While I am, of course, prepared to answer questions about any of the 5 claims before the court, I was intending, if I may, to begin by discussing claim 3 from our brief, which is the claim that the trial judge misapplied the relevant standard for considering mitigating evidence and thereby failed to appropriately consider or give effect to any of Mr. Allen's mitigating evidence, and then proceed to discuss claim 1 from our brief regarding the involuntary nature of Mr. Allen's guilty plea as a result of the unfulfilled assurance from the trial judge of a life sentence. So as to claim 3, there are really 2 fundamental problems with the trial judge's sentencing analysis in this case. First, the trial judge improperly restricted his consideration of mitigating evidence to evidence that touched on Mr. Allen's mental state at the time of the trial and at the time of the crime. And second, the trial judge, even within that restricted framework, employed an unreasonably high, unconstitutional burden for the consideration of mitigating evidence, the competency to be executed standard. So we are, of course, here in this court viewing everything through the lens of AEDPA, and both of these constitutional errors, the state courts were unreasonable under both D1 and D2 in failing to correct them.
Counsel, can I ask you a question? So your position is that that claim that you just outlined, that the judge improperly restricted himself to mental state at the time of the crime and at trial, and within that, the standard was too high, that claim was adjudicated by the state court, the state PCR court addressed that claim?
So they did, Your Honor, via an ineffectiveness argument and ineffective assistance of counsel argument in PCR. Okay. I actually think it's a close question as to whether the underlying constitutional claim is before this court. We raised it, at least as I view it, as both the underlying claim in our habeas petition and here in this court, as well as the ineffectiveness claim that goes along with it. And the state, the warden, conceded that it was exhausted. So to the extent the court, wishes to rely on the state's concession of exhaustion, they're both before this court. But I fundamentally don't think that it makes a big difference either way, because the state court adjudicated the ineffectiveness claim solely on the ground that there was no underlying constitutional violation.
Okay.
Really
so you think your position is the AEDPA deference standard applies to this claim because the state court adjudicated it in the course of adjudicating the ineffective assistance claim?
I think that's fair, Your Honor. They specifically said that the underlying claim did not have merit, and as a result, there was no ineffectiveness. So yes, I think that's fair. So in any event, there are 2 constitutional issues. The issues with both of these aspects of the sentencing determination. So Lockett versus Ohio, Eddings versus Oklahoma, and Tenard versus Drecke all render this claim, all make clear that there was an 8th Amendment issue with this claim. So Lockett says that the capital sentencer cannot be precluded from considering any aspect of the defendant's character and record that may serve as a basis for a sentence less than death. Eddings says that a sentencer cannot give such evidence no weight by refusing to consider it as a matter of law. And Tenard says that you cannot impose a nexus requirement between the crime and the mitigating evidence, which is really exactly what the trial judge did here. So I'd like to focus, if I may, on Eddings, which I think is really strikingly similar to this case. It was also a bench trial, and the claim at issue there really turned on just a single sentence from the trial judge's oral sentencing in that case, where he found that he did not believe he could consider any aspect of the defendant's background as a matter of law. Here we have multiple statements from the trial court that he was focused exclusively on the mental state at the crime and at the time of the trial, and also that he was imposing this singleton standard of competency to be executed, which is just, it's an extreme standard, frankly. It is far, far, far higher.
Are you referring to statements in the letter that the judge filed in response to the promise accusation, or are you referring to something at the sentencing?
There are numerous things, Your Honor. I think both, in addition to the report of the trial judge, which was also post-trial. So there is, of course, the sentencing itself, where the court specifically focused on mental state at the time of trial and the crime, where the court explicitly discussed, quoted, and then applied the singleton standard, and where the trial judge stated that the defense was raising mental illness as its reason in the singular for avoiding the death penalty. So that all occurred at the sentencing itself. There was also the report of the trial judge, where the only thing that was discussed was the mental health evidence, and the judge specifically noted that he didn't find any mitigating circumstances. And then, of course, there was the affidavit, which came several weeks after that, where he specifically...
I thought there was a statement at the sentencing where the judge acknowledged that he had considered the background testimony, the testimony about the defendant's background and upbringing.
Unquestionably, there was, Your Honor. The trial judge did say that he considered the background evidence from Ms. Gray, the defense social worker. But if I may point, Your Honor, to Lockett. In Lockett, which dealt with the Ohio death penalty statute, there was a similar indication in the statute that said, the sentencer shall consider everything with respect to the defendant's background, but then kind of restricted it to these three very narrow mitigating circumstances. So the fact that there's just sort of this general indication that that was considered doesn't answer the question. It ultimately has to be considered under the actual appropriate standard, which is anything that could serve as a basis for a sentence less than death, and not solely mitigating evidence that has a nexus to the crime itself. So
you think the judge acknowledged that evidence, but then excluded it from his consideration?
I think that the judge...
Am I understanding you correctly?
I think that the judge consider. I mean, I'm not suggesting that the trial judge was stating inaccurately his thought process, but I'm saying he considered it only as it went to these narrow issues of mental state at the time of the crime. Excuse me. So that consideration, although genuine probably on the behalf of the trial judge, was ultimately meaningless, because the fact, for example, that Mr. Allen's mother refused to get him medication when he was a 19-month-old baby, and he, as a result, developed pneumonia, has nothing to do with his mental state at the time of the trial. So the consideration was in effect illusory. So the mere fact that he stated he considered it doesn't change the fact that we know that he was explicitly applying an incorrect standard, which is the issue. And
is it correct that defense counsel argued those cases about mental state before the sentencing judge, that defense counsel brought up those cases and argued the cases that the judge then addressed?
Is Your Honor referring to Atkins and Roper and Ford versus Wainwright, or Singleton?
I believe, I don't have it right in front of me, but I believe it was the Roper line, and those cases where those were actually argued, and the judge then addressed them in light of counsel's argument.
That's correct, Your Honor, but it still does not, neither Atkins nor Roper nor Ford versus Wainwright have anything to do with mental state at the time of the crime or mental state at the time of trial. Those are categorical bars to the death penalty. And so they were really beside the point. So the fact that counsel argued them may have been why the trial judge referenced them in his sentencing order, but they really don't go to the heart of the claim, which is his focus on the nexus to the crime and the Singleton standard. If I could just say a word about the Singleton standard, that was the only standard that the trial judge referenced in terms of mental health evidence. There was no other standard other than comparing it to other competency to be executed standards. And so there's really no reason to think that he did anything but apply that standard directly, which he explicitly stated that he did.
Counsel, can I ask you just to clarify something for me about exactly what your claim is? And it was helpful to me, your introduction. You said the first problem is the judge only looked at evidence that would go to mental state at the time of trial and the time of crime. And then you said, and this is my question, within that framework, he set the standard too high at competency to be executed. And as I read the transcript, it looked to me that it was slightly more complicated than that at the time of trial, he was talking about competency to be executed. But I would have thought your argument was that to the extent he was looking at mental state at the time of the crime, that's where he made the nexus error. He was only looking to evidence of a mental illness so severe that you could attribute the crime to the mental illness. But you think at that stage too, he was asking at the time of the crime, was there a mental illness that would render him death ineligible? Or is that the same thing? What am I?
I think both are true, Your Honor. It is a little bit confusing. I agree, because the trial judge is not particularly clear in what he is applying, other than that Singleton is the only thing he states. And he says there is no guidance for how to consider mental illness in the context of capital sentencing, so I can only look to Singleton as a guide. And he didn't identify some separate standard for the trial determination versus the time of the crime determination. Singleton is really all that he said. So I think.
Okay, so so as you just said, like the trial judge, and I'm not trying to fault anyone, this transcript is hard to sort of get your hands around because there's not a lot of place setting, which is fine. But that sort of brings me back, I guess, to my first question. The cases you're relying on, like Eddings, those are direct review cases, right? Where if the transcript's ambiguous, of course you send it back. It's a death case. Let's get this thing squared away properly. But we're under AEDPA now. And so to the extent there's ambiguity and the PCR court has looked at the same transcript and said, here's how we're construing it, it's a different inquiry. If it's ambiguous, that's sort of a classic case for AEDPA deference.
Your Honor, I respectfully disagree that it's ambiguous. I think that the court said over and over and over again that he was focused on the trial nexus and the time of the crime. He says, I would just like to alert the court to one other place in the record that we didn't identify in our briefs, but at page 800 of the joint appendix, the state actually objects to a portion of Dr. Crawford's testimony about saying, this goes to mental state at the time of the crime. That really has nothing to do with this case. And the judge says, I think that's the ultimate issue in this case. So there again, he says it in his post-trial affidavit. He was very clear, I needed to be convinced that Mr. Allen was so mentally ill at the time of the crime and so mentally ill at the time of trial that his execution would violate the Eighth Amendment. I just don't think that that's ambiguous at all. And so the state court was unreasonable in suggesting, the state court didn't even find it ambiguous. They just found, well, that's not what he did. I think it is the exact opposite of that. And again, I agree that Eddings is, for example, a direct review case, but I would point the court to both the dissent and Justice O'Connor's concurrence in Eddings. The dissent reads almost exactly like the state court opinion in this case. They say, well, that was an ambiguous comment, or at least it could have been, what the judge was really probably saying was that he considered the evidence but gave it little weight. And of course, the Eddings court rejected that, and Justice O'Connor in her concurrence specifically stated that Woodson and Lockett require any ambiguity to be resolved in favor of the defendant to ensure that all mitigating evidence was properly considered. So even though those were direct appeal cases, the clearly established federal law is that those ambiguities are required to be resolved in favor of the capital defendant. So it was just unreasonable within the scope of EDPA. I would also point again to the determination that they made that the judge actually considered everything but gave it little weight. He expressly stated that he found no mitigating circumstances. Yet we know that the judge believed that the mitigating circumstances were factually established because he, in fact, held Mr. Allen's abusive childhood against him as we set forth in Claim 4. So he believed it was factually true, but just didn't find it as a mitigating circumstance because he was applying the wrong standard.
Next question. Does it help your argument under EDPA that the state PCR court appears to have looked only at the transcript in resolving this question and not other evidence in the record like the report and the affidavit?
Absolutely, Your Honor. I think that the opinion of the PCR court is extremely short in this claim as compared to its opinion with respect to the other claims. And they really focus very narrowly on that transcript without considering everything else, exactly as Your Honor said. And that was unreasonable because they basically ignored very straightforward evidence that the trial judge was in fact applying the wrong standard. And I see that I'm almost out of time.
All right. Thank you, Mr. Adjourn. Ms. Brown.
Thank you, Your Honor. May it please the court. Mr. Allen has presented 5 issues, and all of those 5 issues were considered by the state courts, either in the trial court level, direct appeal, or PCR court and PCR appeal. And that prompts the deference provisions of 2254D. It also prompts the provision of 2254E1, and that is that the factual findings are presumed correct. And of course, there are some credibility rulings within each of these issues. And this court has said for that particular fact finding, the error has to be stark and clear to jettison the state court's finding. So the question that we have on all of these issues would be, is the ruling objectively unreasonable? Was that ruling so obviously wrong that it's beyond any possibility of fair-minded disagreement? And the warden would respectfully submit that that cannot be based on this record. The state court records support that Mr. Allen's plea was voluntary, that Mr. Allen was not denied effective counsel, that Mr. Allen was not denied any kind of process, and Mr. Allen was not denied an expectation of a certain sentence because he didn't have one. He had no expectation, and that really was the finding that was dispositive in the involuntary plea issue and in the ineffective assistance of counsel linked to that issue. So in essence, no relief is due, and it's not due because of the strength of the state court record and the deference.
Counsel, can I ask you a question that will sort of, I think, take us from the guilty plea over to the mitigation evidence? And this is my biggest concern about the case. On the guilty plea side, the PCR court found, and you want us to defer to this finding, that there was no promise. The judge obviously indicated that he was inclined to sentence to life, but it was conditional on this one key thing, which was that counsel could prove up serious mental health issues. that would persuade him to then give a life sentence. So that's how we dispose of that. But if what happens after that is that the judge applies the wrong standard to the mitigating evidence, so that even though counsel reasonably believed I can prove my case, it turns out she can't because the judge used the wrong standard, then in the context of this case, that would be a particularly concerning mistake to have made, right? Because it would throw into question sort of the whole premise for how you want us to resolve the guilty plea problem. Do you see what I'm saying?
I think I do, and if I can kind of go back to the mitigation case, I think that it's important to remember that the judge didn't have to set all this out. He was sort of giving a glimpse into the way that he was looking at different pieces of evidence. He did not make a comprehensive dissertation on how he was weighing things, but he was trying to address what was said to him. And if I could...
Okay, so counsel, sorry, and I don't mean to interrupt, but I think it would be really helpful to me to make sure I'm understanding what you're saying, because I think it may narrow sort of the differences between you all. So you are not saying that if in fact the judge said, I will only look at mitigating evidence to the extent it bears on state of mind at the time of crime or death eligibility today, that would be okay. You're saying that's not what happened.
That is not what happened. That is correct. That
Okay.
is not what happened. And I would point to counsel's own argument at the Joint Appendix 1564 to 65. The reason we are here would be the crimes, and the best evidence he is mentally ill that we could ever present to you were the crimes. And then she discussed the crimes in context. So if you read in context Judge Cooper's sentencing comments, then he's saying, I'm addressing what you're telling me. I'm looking at this specifically. This is what you've asked me to look at. So no, he has not disregarded background, and no, he has not used an improper structure for consideration of the evidence. And I think going back, I believe it was Judge Rushing who said that, well, he has a listing of things, including the background for Mr. Allen that was chronicled and presented that he considered. Well, that would also be any evidence of any kind of psychiatric illness. I would also point out that the evidence of psychiatric illness was not at all conclusive. Even in the PCR, when Mr. Allen is once again evaluated for competency, Dr. Frierson said there were numerous opinions on either side of the fence, from reaching into insanity to having malingering. It's
okay, Counsel, can I ask you to clarify? Are you saying that the state experts here were saying this Mr. Allen has no psychological problems at all? That the things like the inpatient psychiatric hospitalizations, that was disputed, and the rumination disorder where he re-eats food, that was all disputed?
That he re-eating food, I do not believe was disputed. The personality.
Okay, well, that's a pretty that's a fairly serious, right? So everyone was agreeing there is some serious mental health issue here. What was disputed is, does it rise to the level of schizophrenia or something that would cause delusions and things like that?
Certainly, there was no agreement whatsoever on schizophrenia or schizoaffective disorder, nothing like that. There were also arguments, individual factual arguments, on whether something was prompted by some potential delusion or not. For instance, in the Roadhouse killing, there was argument that from the defense expert, Dr. Crawford, that was not some part of some delusion. That was because he was mad. So all of this went back into facts of the crime because that's where defense counsel was going. So again, I don't fault Judge Cooper in the PCR court didn't find counsel ineffective for not objecting based on some kind of wrongness in the evaluation. And to step back and just look at it from a global perspective, if counsel objected to the judge looking at the crimes, then their objection.
Ms. Brown, I thought problems. the degree that was disputed, but the problem. But here's the question, not to you, directly to what was argued by Mr. Jordan. You can consider something, but if the metric you put to the consideration of the evidence is too high or clearly inappropriate, that may be a problem. And what I'm saying is that he clearly said he was looking at an Eighth Amendment standard. In other words, it's not a mitigator unless it would be constitute cruel and unusual punishment. And in Ford, that's the, as counsel said, that's the highest one. You have to be so out of it that you don't even know you're being killed, or even the reason why you're being executed. And then to say just only to the crime or the time of sentencing, the standard is too high. I mean, how can the PCR court find something that the court clearly said, this is what I need to have before you, this will be a mitigator. And that's too high. Isn't that wrong?
Well, sir, that doesn't look at it in the way that it was presented to the PCR court. The PCR
no, about what the judge said. The PCR court can't change what the judge said. I mean, in other words, deference is one thing, magic is another. You can't make something just go poof, put it away because you're on the PCR review. The judge told in simple English what my standard was. And he said it's an Eighth Amendment standard. It's cruel and unusual punishment. Before, it would be, for me to put you to death, that would be the standard. And talked about Ford standards, that's the wrong standard. Forget about whether he considered things, but the point is, what is the metric? And the metric is wrong as a matter of law. Do you agree with that Ford is not the standard for a mitigator in the death case? Or that the Eighth Amendment, unless it reaches Eighth Amendment level, is not a mitigator? Do you agree with that?
Ford wouldn't be for competency to be executed. That is not a mitigation.
What about the Eighth Amendment? Do you believe this has to rise to the level of an Eighth Amendment type level before it can be a mitigator?
I believe that the cases that the judge referenced, including Atkins, talk about the culpability of the defendant. And I believe that is very clear from the context of Judge Cooper's comments that he was looking at culpability of the defendant. And he was looking at the character evidence presented to him. And that is bound up not only in background, but diagnosis, conflicting diagnosis, as has been mentioned here today.
But you're not answering my question, though. I'm asking you, do you agree that the Eighth Amendment is the standard for a mitigator?
I don't believe, well, Your Honor, respectfully, as I understand what you're asking me, I would have to say that the Ford standard is not mitigation. But I don't believe that Judge Cooper used the Ford standard to block mitigation. He used the Ford standard as an example of looking at culpability, looking at a defendant and personalizing the sentence, individualizing the sentence. And that is mitigation. That is sentencing. That's proper sentencing. So he didn't just say Ford, he didn't just say Atkins. He was looking at the reasoning in the cases. What would support retribution? Well, it has to be the character of that defendant. You have to look at him. That's individualized sentencing. So that, Your Honor, respectfully, is a little bit of my hesitation, because he didn't just say, I'm using a Ford standard. He said, I'm looking at these cases, they're delving in to what the culpability level would be. And that's what he was attempting to do, and attempting to do it.
Ford is not
I'm sorry.
Go ahead, Judge Harris, go ahead.
No, you go, Judge Gregory.
I was just saying, Ford is not a culpability standard. It's saying that you could have done the most horrible of horribles. But it's saying that the point is, it makes no difference in terms of retribution if the person doesn't even understand they're being killed and for what reason. That's what Ford is.
Exactly, retribution. That means, can he understand why he's even being executed? And that was the type of global
Where in this case was there anything near that in terms of anybody saying that he didn't even understand what was going on? That's not even this case. Atkins wasn't this case. Mental retardation was not even the case. Why would these cases be even in the mix if it was not what the judge said, this is my standard? You can only judge the court by what the court says. You can't wish something away because you want a finality of a death sentence or any other kind of sentence.
Absolutely. And Your Honor, we have to look at it in context. When we isolate it, we're not being fair to anybody.
I'm not isolating anything. I'm just saying that's what he said at the sentencing.
And he did say that. He did. But he said it, Your Honor. And I think this is really critical. And I'm glad we're having this discussion.
Critical.
Because it's critical because it's an element. It's not dispositive. He's looking at it as, what does the Supreme Court tell us? And the Supreme Court tells us that these sentences have to be individualized. We have to look at this individual, this man who the state of South Carolina is seeking a death sentence against. We have to look at him. We have to look at what he did. We have to look at his crimes. We have to look at his background. And Judge Cooper did that and also addressed specifically what he was asked to address by defense counsel. Defense counsel tied the crime to the mental illness to try to increase the credibility of the mental illness presentation in mitigation. But at the end of the day, Your Honor, this is the problem with the mitigation issue. And that is, there are no findings required in mitigation. There is no effect to mitigation that can be defined. But you cannot prevent admissibility and you cannot prevent consideration. That doesn't mean that you can't consider it one way and consider it another way. You're not limited to a box of consideration for one particular.
Didn't find any mitigating. He checked no. Court said no. Checked no. There were none.
No weight. No weight.
No, it doesn't say no weight. Counsel, it doesn't say no weight. And I'm glad Judge Gregory raised the form because I am sort of struggling with, given that there was undisputed evidence of some pretty compelling mitigating circumstances here in terms of his sort of the extreme childhood abuse and the very serious mental health issues, putting to one side the dispute over schizophrenia. How do you get to there was no evidence of mitigating circumstances supported by the evidence? Somewhat redundant, but it doesn't say I didn't give it any weight. It says there was none. And then he clarifies, to be clear, the reason I found no conclusive proof of mitigating circumstances was that there were conflicting diagnoses. But as we've discussed, the conflict, there was no conflict as to a whole bunch of very compelling mental health issue evidence. The only thing there was a conflict about was the schizophrenia. So it just looks to me like this form, I want to give you a chance to address it, but I will tell you my concern is that I'm having trouble reconciling this form with the judge who did think there was mitigating evidence of mental health issues below the level of schizophrenia, that, as the judge says, there was nothing there to show that the disease controlled his mind at the time of the crime. It looks to me like the judge is saying, was he suffering from schizophrenic delusions at the time of the crime or not, period. And I'm really having trouble reconciling this form with your account of what happened. So let me stop talking and give you a chance to answer.
Thank you, Judge Harrison. I do understand your question, but I think it goes back to the structure that we have in South Carolina. There is never a report of mitigating circumstances that's required from any jury. There is never a direction that you must find mitigating circumstances. That is not the way that our statute works in South Carolina. The only thing we have are, we have a requirement that a finding of at least one, there could be more, but there has to be at least one statutory aggravating circumstance. That is eligibility, and that's it. That's all that has to be reported for the sentence.
So what is the form for? Why does the judge, what does it mean when a judge fills out a form and says, I found no evidence of mitigating circumstances, period?
The form is governed by 16.325. The Sentencing is governed by 16.3.20. The form is given to the Supreme Court, whether there is a jury or whether there is a judge. So, Your Honor, respectfully, I would think at this point, it is helpful for the aggravating circumstances because that's listed out. That's required to be designated. But as far as mitigation, that's any other fact finder. Anybody can take anything as mitigating in favor or against. It's not a requirement. So that would be too narrow a reading under our statutory scheme in South Carolina. That is not dispositive. That doesn't mean that there's been a rejection. It means that it wasn't weighty enough. And I refer the court back.
That's not what the form says. I mean, I understand what you're saying. You could have a form that says, did you find mitigating evidence that outweighed the aggravating factors? If so, what was the mitigating evidence? But that's not this form. So I don't.
And other jurisdictions do have a statute that says that the fact finder has to list it out. Our statute does not. We don't. This form is generalized. And again, it's for the judge to fill out whether he's fact finder or whether he's presiding. So it is universal in that way. It is not helpful in determining the mitigation. And at some point, you would get into the prohibition of going into deliberations. As I said, Judge Cooper did not have to go into everything that he did in his sentencing order. So we have a glimpse, at least into part of his consideration. But he did not in any way reject evidence at all. In fact, this was a 10-day sentencing hearing. It was highly contested. There were several mental health experts who testified. Nobody was rejected, and I will not listen to anything, get out of the courtroom. There was no report that was found inadmissible. There was nothing to that level. So respectfully, I think that the 16.3.20 provisions have to control, and the PCR court was right in looking at this again, not as freestanding, but as an element of the ineffective assistance of counsel claim. And frankly, it would have been inconsistent for counsel to object when they've asked the court specifically to look at the crimes and as evidence of mental illness. And I see I'm out of time.
Oh, you may continue your thought. You may finish.
Your Honor, we will rely on the strength of the state court record in our brief, and I thank you for the court's time.
Thank you, Ms. Brown. Adjourn, you have some time reserved.
Thank you, Your Honor. If I may just start with this question of the South Carolina death penalty law not requiring any findings. Respectfully, opposing counsel is conflating the issue of whether findings need to be recorded in writing with whether they need to be made at all. We've set forth the relevant South Carolina law in both our opening brief and in our reply, and it's clear that mitigating evidence in South Carolina can only be given any significance if it's actually found. It's not surprising that only statutory aggravating circumstances would be required to be designated in writing because those are effectively elements of the crime. And this notion that the judge didn't have to say it, it doesn't mean that we ignore it. It's basically the same as Eddings. It was a bench sentencing in Eddings as well. The trial judge made the comment that clearly reflected that he was applying an inappropriate standard, and that's exactly what we have here. It's really quite similar. This general notion that counsel was saying you take the crime into account is not in any way contrary to our argument. There's no suggestion that the judge needed to ignore the circumstances of the crime or that those could play absolutely no role whatsoever into his evaluation of Mr. Allen's mental state. It just couldn't be.
Counsel, I'm going to stop you for a second. You argue the case the way you want, but I'm surprised you have not mentioned, do you concede that this was no problem? Judge Harris raised it about the promise or inducement or alleged, whatever, and how that connects with both the voluntariness of the plea as well as ineffective assistance and all of those things.
Your Honor, thank you, Your Honor. I do think it's important. I think I agree with that 100%. The point that Judge Harris raised that anything that was sort of premised on the idea that there still needed to, and that the trial judge apparently had a completely incorrect view of what the appropriate consideration of mitigating mental health evidence actually was. So that absolutely supports our involuntariness claim, claim 1. There's no question about it. And I could just, if I could just add very briefly, we believe that the state court was unreasonable both in determining that there was no assurance because they completely ignored this comment that Ms. Pringle, Ms. Sampson, and Mr. Lominack all testified to about there will be no PCR proceeding directly in response to a question about or a statement about I can't be up there, testifying in a PCR hearing with an assurance.
So would you agree then, given what Ms. Brown said about the normal practice about how we deal with mitigators and not required to say that in this particular case, it was particularly important because it was somewhat a basis, it seemed to be, as to weighing that mitigators, whether or not that was going to be enough to follow through at least an inclination of a life sentence. Do you agree with that?
I'm sorry, Your Honor.
What I'm saying is that, and because of the facts of this case, would it be more particularly important to look at how these mitigators and evidence was looked at, where here there's evidence where the judge had this pre-plea meeting, whatever you want to call it, whether it was, people, some enticement or whatever, but at least there was some indication of at least an inclination on the judge's part that this might result into a death penalty. Does that make this case more important that you have to look at how and what standard would use to fulfill what the judge at least maybe perhaps was looking for in terms of what level of evidence to assure him that a life sentence would be appropriate?
Yes, Your Honor, I think it just highlights the degree to which the judge's inappropriate focus on the wrong standard was prejudicial because, as Your Honor noted, he expressed that he was at least perhaps favorably inclined pre-trial. And so it just highlights the prejudice that he was employing the wrong standard. I hope that answers Your Honor's question.
That's fine. Well, I interrupted you last minute, so do you have anything else to say?
Your Honor, I was just going to very quickly wrap up with, I think, what this, to touch on the claim 1 about the involuntary plea, just to say that the second critical unreasonable determination that the state court made was that Mr. Allen did not, in fact, rely, or the promise did not induce his plea, where he specifically and explicitly testified that he would not have pleaded guilty without his counsel's advice, and they only advised him to plead guilty because they understood it as an assurance of a life. So that was just what I was going to wrap up with.
You trailed off at the end because they understood it as a what?
I'm sorry, Your Honor. I was going to say that was just what I was going to wrap up with. That was the second critical unreasonable determination that the South Carolina post-conviction court made.
All right, thank you. All right, Mr. Adrian, Ms. Brown, thank you so much for your arguments. We appreciate this. We always like to have good counsel here to help us on these very difficult cases, and you both have done well in doing that. Thank you. We can't come down and shake your hands as we would normally do in our fine Fourth Circuit tradition, but know that we appreciate your arguments, and be safe and stay well.
Thank you, Your Honor.
Take care. We proceed to our second case. Mr. Coates?
Yes, sir. Good morning. Please the court. I'm David Coates. I represent the plaintiff appellant Skyline Restoration. We do disaster remediation and restoration work throughout the country. And we're also, we're based in Blue Island, Illinois. We also stand in the shoes of First Baptist Church of Lumberton in Robinson County, North Carolina, as their assignee. It's a statute of limitations case. So if you'll bear with me, I'll kind of run through the timeline, which I don't think is in dispute whatsoever. October 7, 2016, Hurricane Matthew comes through southeastern North Carolina, causes extensive damage to the counties in southeastern North Carolina, including Robinson. It causes extensive damage to the First Baptist Church of Lumberton. And the First Baptist Church of Lumberton is not some small church. It is rather large. And as reflected in the insurance policy declaration pages in the appendix, It consists of 5 separate buildings. It is a large campus, and it had a great deal of wind damage, a great deal of flood damage. It had no fire damage whatsoever, but a lot of wind damage and a lot of flood damage. So the church enters into a contract with Skyline October 18, 2016. We proceed to work extensively and bring in massive crews for the next 2 months. We end our work on December 15, 2016. The church had in effect this policy with Church Mutual. Among the many perils it covers is our wind claims. They have a separate policy with Lloyd's, which covers flood damage, and is reflected in the bankruptcy proceeding. All claims of Lloyd's have settled. And there's no allegation that the church didn't pay their premiums or the policy wasn't in full force in effect. And again, we're dealing with wind damage claims, no fire, no flood. Skyline filed a claim of lien. We've got to do that by statute within 120 days of last filing or furnishing of materials to the project. On February 16, 2017, on August 30, 2018, Skyline filed their Chapter 11 proceeding, which stayed all collection efforts. And then the critical date is April 4, 2019. As reflected in the complaint, at that point in time, the church sends a comprehensive proof of loss package to Church Mutual saying, for the wind claim, here's all the documents you need. We're making this claim now. Please proceed and respond to this claim. And that is the earliest date on which I believe a breach of contract against Church Mutual can begin. The clock begins to run on that. And so again, no one claims this work wasn't done. No one claims that we did not have massive crews there for 8 weeks to do all of this restoration work. No one claims that the church was not obligated by the policy, as they are, to perform immediate mitigation work in order to prevent future damage. As set forth in the brief, they absolutely have that contractual obligation. And so that proof of claims filed by the church on April 4, 2019, no response by Church Mutual. No response to the church, no response to Skyline. On September 9, 2019, the church files an adversary proceeding in the bankruptcy case. Subsequently, Skyline and the church enter into an agreement which includes the assignment in this particular case. And then November 22, 2019, this action was filed 8 months after the breach of contract. And so there's no dispute that the suit was filed well within 3 years of every single pertinent date, except for Hurricane Matthew. It was filed 3 years and 7 weeks after Hurricane Matthew.
Okay, and Counsel, can I ask you a question?
Sure.
I definitely understand the kind of the state of the land here. If Hurricane Matthew had caused a fire at this church, then you agree, right, that the claim would be governed by the by 584416, and the accrual date would be the date of the hurricane, right?
For the fire portion of that claim, I think you have to separate
why?
it
Can you
out.
just tell me why it would make sense to have different statutes of limitations if Hurricane Matthew blew off half the roof and set on fire the other half? You're saying that what the North Carolina legislature intends is that half your claim will be governed by one statute of limitations and half your claim will be governed by a different one. Why would that make any sense?
Oddly enough, it's really kind of hard to sit there and correlate 58-3-35 saying, insurance company, you cannot limit what somebody can sue you for. In the Piles case, that the breach of contract occurs when you breach the insurance contract, not the date of loss. In 58-44-16, unless you read 58-44-16.
Counsel, I'm just asking you, I understand the statutes, and I totally am tracking your statutory argument, but I guess my question is a little different, which is, in your view, what was the North Carolina legislature thinking? Why did they want half of that roof to be governed by one statute of limitations and the other half governed by a different one? Because I'm just saying the statutory scheme, in just assuming hypothetically, it's sort of complex and maybe a bit difficult to follow. You'd want to know why your interpretation of it makes sense.
I think the North Carolina General Assembly, when enacting 58-44-16, intended there to be uniformity with fire insurance policies and fire insurance policies, period. We want those, and that's why you see in personal lines and commercial lines, they track the exact language of the statute. But with respect to every other peril, I think the intent of the General Assembly is that the breach of contract occurs on a different date when the breach occurs, not when the loss occurs. And so they wanted it very narrow. And it corresponds with the rules of construction in North Carolina that things that broaden coverage are construed broadly and things that restrict coverage are construed narrowly. And so we have the policy in the appendix is 190 pages long. On page 32, yes, Judge Rushing, yes, ma'am.
There I am. Sorry. I want you to answer Judge Harris's question, so I don't want to take us off on a tangent. But
Sure.
Your answer, I think, is getting at a question I had. That there seem to be two questions here, and I want to know your position on each. One is this a fire insurance policy? And then, if it is, why aren't all losses under the fire insurance policy treated the same, which I think is the question that Judge Harris is asking, that why would we apply a different statute of limitations to different losses if all of these losses are occurring under the same policy? Your argument in response seems to be suggesting, well, this policy is not a fire insurance policy, but I don't want to assume what you're about to say, but I see two different arguments happening here.
No, Your Honor is correct. There is a fire insurance policy which is part of this multi-peril policy, but it is not, the policy that's in that appendix is not a standard fire insurance policy in no way, shape, or form. 3 pages, 120 to 122, are the fire insurance policies. The other 190
Well, the North Carolina law seems to treat it as you have a fire insurance policy and you have to have certain required provisions, and that's your standard fire insurance policy. But Crawford and these other cases from the North Carolina courts suggest that it's a fire insurance policy if it includes fire insurance, and it may include other things, but that doesn't mean it's not a fire insurance policy.
I think absolutely the General Assembly did not sit there and say, insuring public, we're going to restrict your rights to sue the insurance company when they breach the contract by saying in a 190-page policy, the 3 pages that are the fire insurance policy means that statute restricts everything you have. So if you breach, and for example, 58-44-16 says this doesn't apply to auto, comprehensive, and collision. Well, for example, on page 216 of the appendix, you know what the policy has? Auto, comprehensive, and collision. So does that mean that the policy, that statute doesn't apply whatsoever? Because the statute says 58-44-16B, with the exception of policies covering auto, fire, theft, comprehensive, and collision, and marine and inland marine. And then the policy has coverage for rental car, comprehensive, and collision. So by the very terms of the statute, that doesn't apply. And so how can you sit there and say, yes, ma'am?
Counsel, can I say, so, all right. The statute, section 152.12, the one that makes the exception in the first place, says that the exception covers any insurance policy that is subject to the 3-year limitation contained in 58-44-16. And you already told me, right, that if there had been a fire in this case, that 3-year statute, that other statute of limitations from 58-44-16 would have applied. So this insurance policy, whatever you want to call it, it is subject, at least in part, to the statute of limitation contained in 58-44-16, right? And so they're not asking, I guess I'm stuck on the language of 152.12, which, and this I guess just goes back to Judge Rushing's question. It doesn't talk about whether the loss is subject to the 3-year limitation. It talks about whether there is an insurance policy that is subject to the limitation. And any insurance policy that includes fire insurance is going to be subject to that separate limitations period. So I'm having trouble making your argument work with this language.
I think that would be a boon to the insurance industry if you could sit there and say, I'm going to restrict your rights and I'm going to reduce the statute of limitations for everything covered in this policy, because it has, in page 32 of the appendix on the declaration page, it says standard fire policy, insurance policy provisions. So that is a policy within a policy, respectfully, Your Honor. You cannot say every other peril in there, including auto coverage, comprehensive coverage, which is accepted from the statute, everything has to fall in. That is topsy-turvy for the way things are construed in North Carolina and insurance policy state by state. It's construed in favor of the insured and in favor of coverage. And to sit there and say, for every single peril in here, you just lost your statute of limitations. It's reduced because part of this policy has a fire insurance policy. And respectfully, I just can't imagine that you can subject the consuming public to that standard. I think that's very
What is your
Yes, ma'am.
what is the best North Carolina case for that point? Where is there a North Carolina case where there was a policy like this that covers fire, but because the peril was something other than fire, the court said that the statute of limitations does not apply?
I don't think there's any case directly on point. I think the F&D Aetna case says, that 58-3-35, you cannot reduce the statute of limitations for breach of contract. But I think the cases like the Marshburn case, the Page case, and the Quillen case all dealt with personal line homeowners policies, which are very, very narrow. It's not like a multi-peril commercial policy that the church has for a multitude of buildings. And so it is completely apples and oranges. A homeowner's policy, for example, yes, ma'am, Judge Harris.
Sorry, Counsel, I take your point about you wouldn't want to upset a lot of expectations in North Carolina, like come in and mess this up. But I find some reassurance in the fact that there are a bunch of horn books in addition to cases, but the horn books all say, look, it seems a little counterintuitive, but North Carolina law just uses the term fire insurance policy interchangeably with property insurance policies. It's an odd quirk of North Carolina law, but it seems to be well understood. So I am less worried because of that about upsetting expectations, but I want to give you a chance to respond.
I'm not sure how you can correspond that, Your Honor, with 58-44-16B, that the statute doesn't apply to policies providing first-party property coverage for auto, comprehensive, and collision.
Yeah, except for auto. I should have said the horn books do cover that. They say, but for auto, we're just using this interchangeably with basic property insurance.
Okay, and I think, Your Honor, respectfully, that the auto coverage is basic first-party property coverage. And how can you separate those two and say, consuming public, now everything in this 190-page policy is subject to restricted statute of limitations, when you shouldn't be? When that statute says if the policy covers auto, comp, and collision like this one does, the statute doesn't apply. And so I think it's to the great detriment of the consuming public that the insurance industry would be allowed to restrict the statute of limitations when people are damaged by breaches of contract by saying, I appreciate that the clock was run out and they breached the contract 2 years later, but you're on the clock. You've got 3 years from data loss for stuff completely separate and apart from fire loss, which isn't the issue here. What's like watching the 24-second shot clock go off. So I think I reserved 5 minutes, but I think my time is out.
You did, Mr. Coates. Thank you. Ms. Kabule, Olia, you're muted. You're muted.
Good morning, Your Honors. May it please the court, my name is Mihaela Kabuleya, and I represent the Appellee Church Mutual Insurance. I would like to start by addressing some of Judge Harris's and Judge Rushing's comments and questions. This case, Your Honors, involves definitely a standard fire insurance policy that is compliant with North Carolina law. And here, the applicable statutes, the subject insurance policy, and the case law interpreting such standard fire insurance policies, they all provide for a 3-year limitation from the date of loss for any lawsuits brought on any claims under a standard fire insurance policy. And to answer some of the Honorable Judge Harris and Judge Rushing's questions, I would like to point the court's attention to the most relevant statute here, which is 58-44-16, subsection 18. And I don't really like to read from statutes during oral argument, but I will read just the relevant portion of it, which particularly says that no suit or action on this policy means standard fire insurance policy, or fire insurance policies, so both standard and fire insurance policy, for the recovery of any claim, Your Honors. This means any claim, not just a fire claim. If the legislature wanted to limit the ability to bring a claim, only a fire claim under this particular statutory provision, they would have said so. They would have known to make that difference, to exclude any other coverage, extra coverage that might be afforded under a fire insurance policy. So this is in our interpretation of the statute, there is absolutely no limitation as to the type of claim that is being brought. Just because the fire insurance policy in this case is broader and it provides additional types of coverage, it does not mean that a different statute of limitation applies to that additional type of coverage. And then obviously the case law that was also cited in our briefs and was relied on by the district judge in this case also supports this interpretation. There have been cases that interpret losses, especially the case that is cited in the district court's order, and it's the case is Page versus Lexington, and there the loss was not a fire loss; it was a pipeline rupture that was at issue and caused the damage, but the court basically applied the same statute of limitation that is applicable to any fire claims. So the 3 year from the date of the, it's called the 3 years from the date of the inception of the loss, but that has been interpreted to mean the 3 years from the date when the damage has occurred that led to the cause of action. So that would be here, Hurricane Matthew.
Counsel, may I ask you a policy question? Pardon the pun, but I mean public policy in terms of these types of contracts. And I understand very well the questions Judge Harris and Judge Rushing. But mine is more of a public. Do you agree that North Carolina, like many states, you sort of presume coverage?
I would agree to that, Your Honor, that coverage is presumed, but not. It wouldn't be presumed if it's excluded from the statute.
No, it's not a trick question. It's not a trick question. That was just the first part. It presumed, otherwise, like in baseball, the tie goes to the runner type thing. So the tie sort of goes to the insured. You agree?
Yes, Your Honor.
All right. So now follow me now. This is a policy I'm trying to understand this. The general rule is that it's from the time of breach, but of course, by the layout of the statutory provisions in North Carolina, they say no fire insurance, no, it'll be the time of loss, which, as you say, is basically the time of the event. But isn't it in a sense, it makes sense that it's fire because you can't hide a fire. Everybody knows when a fire occurs, and you know it, right? But that's not true about, for example, other type damages, the property, for example, like wind, for example. But here, the wind could blow 100 miles an hour, and you look up there and you go, oh, whoa, whoa, we're fortunate. It's still up there. But you have no idea that the water seeped down walls and things like that and caused all kind of hidden damage, because water is very destructive but silent and invisible. So wouldn't it make sense that fire, they meant to say, no, fire, everybody knows a fire, get started, you don't notice. It happened that day and everybody saw the smoke and the fire, but the others, it doesn't make sense from a policy standpoint that we got to find out that now we know 6 months later, oh, the water's damaged subfloors, it's done this. And then you try to file a claim and they said, no, we're not going to cover it. Then it starts from the time of the notice, generally as the breach. You follow what I'm saying? Isn't that, so doesn't that make a reasoned way why fire was narrow? Because narrow, fire is the exception to that general provision. Go ahead, you can answer.
I apologize. I saw.
No, go ahead. No, go ahead.
Thank you very much, Your Honor. What I wanted to say, it's the same obvious event that produces, in this case, a hurricane. It's very obvious. We all know that this is the date of loss. Everybody who has any additional types of losses, they can make supplementary claims. It's not like, and even the statute says 3 years from the inception of the loss. So the inception of the loss here was Hurricane Matthew, when everybody knew Hurricane Matthew hit and produced this damage to properties. And if there is some hidden damage down the road, the insured, I apologize, is not precluded from bringing that additional claim to the insurer's attention. It's just that the particular lawsuit should be brought within 3 years from the date of the inception of the loss. And I think that's why the legislature phrased it that way, because sometimes the damages are not apparent right away. There might be some obvious damage, especially after a hurricane, like it is after the fire, Your Honor. Sometimes people don't realize that maybe this, I don't know, the electrical system was all burned, or they realize that later on. But the event that produced the damage is clear both for a hurricane and both for a fire. So that's the inception of the loss. And then I would also like to point out that, maybe in response to opposing counsel's argument that it would be bad policy to restrict the insurers from bringing the cause of action to 3 years from the date of loss, I would have to point out, Your Honors, that the insurer, as I said, the insured is not without a remedy. The insured bargained for a particular contract, was aware that that particular contract includes additional coverage, not just fire coverage, and that the policy itself has the same language limiting lawsuits to 3 years from the date of the inception of the loss. So it's all under the policy. The policy incorporates the language of 58-44-16, subsection 18. So it's not in violation of any North Carolina law. And then the other thing is, sometimes, especially now that we are coming upon the anniversary of Hurricane Florence, insureds are cautious about the running of the 3-year anniversary, I want to say, about running into statute of limitation issues, and have asked insurers for a tolling of that statute of limitation. So it's not like they are without a remedy, and it would be very uncertain and very unclear which statute of limitation applies to such a fire insurance policy. If for each different type of loss, we would go back and forth to different statutes to see which ones govern it, just because it provides additional coverage. That shouldn't be the norm, because it is clear from the legislature intent that basically the suit limitation it applies to any type of claim, Your Honors. And I want to briefly address a novel argument that was made by appellant in the reply brief, and we did not have time to respond to that particular argument that also references a new statutory provision. That argument was not preserved because it wasn't raised in the district court and it was not raised within the opening brief. But even if it were, it is without merit because the section that the appellant relies on, 58-44-20, simply governs additional supplemental coverage, makes no reference to the statute of limitations, and does not have the effect of splitting this policy into a kind of like hybrid policy, fire insurance policy, and then something else that is governed by a different statute of limitation. And so in that respect, the argument regarding section 5844-20 does not change in any way the analysis. And the district court correctly found that it is the statute of limitation provided in section 58-44-16, subsection 18, that applies to this case and precludes and bars this particular action. And then I would like to also, I don't know if there are any issues, any other questions the court has of me.
Can I ask you a question about the UDTPA claim? Just so I understand what the arguments are on appeal. So the district court dismissed that claim on two alternative and independent grounds, that it was not pled properly, there was no sufficient factual allegation of a violation, and then alternatively, under North Carolina law, third parties can't sue other people's insurance companies. Are you defending both of those holdings on appeal?
Yes, Your Honor. We are defending both of those holdings. We believe that both are correct, and the district judge correctly found that the allegations were insufficient. There are two main allegations that appellant is relying on, even in the opening brief. And then one of them is that Skyline allegedly submitted direct cover claims to Church Mutual for a particular amount that was covered by their invoice for the work that they have done on their church property. And then the second allegation is that Church Mutual failed to act promptly when liability was clear. And that particular second allegation, Your Honors, is very conclusory, and it just pays lip service to the statute, to the ADUCTA statute, which there's nothing in the allegations in the complaint that would support that. So the fact that it failed to act promptly when liability was clear is just a conclusory statement, and that's why it was insufficient as pled. And then the second argument was, as Your Honor pointed out, the fact that such a ADUCTA claim, unfair claim practices act, Your Honor, cannot be assigned under North Carolina law, and an assignee, a tort action cannot be assigned to an assignee, and an assignee cannot bring such a claim. So those, we defend both of those decisions by the district judge. We believe those were correct. And then also the district judge's decision on the second issue that's on appeal, the tolling effect of the bankruptcy proceeding, Your Honor. That tolling effect, there was no tolling effect, basically. And I would also like to point out that in this case, the Skyline had already an assignment of benefits that was given during when it entered into a remedial work contract with the First Baptist Church of Lumberton. So it was on October 18, 2016, they alleged they had an assignment. And then this is from appellant's own timeline, the allegations in the complaint. And then the second assignment that was allegedly obtained was during the bankruptcy proceedings, when adversary proceedings were initiated within the bankruptcy proceedings. And then as a settlement, Skyline obtained this second assignment that assigned the same all claims that the church had against Church Mutual for the amount of money that the invoice amounted to. So basically, Skyline had an assignment as of October 18, 2016, and it did not submit a claim until it did not submit a claim to Church Mutual. Could have done so, could have asked for the contract if Skyline had other remedies, like file a claim with the Department of Insurance, a complaint with the Department of Insurance, if it wanted to have its claim resolved. But between October 15, 2016 and August 30th, 2018, when Church Mutual, I think it's, yes, August 30th, that's when the bankruptcy proceedings were initiated. That was almost 2 years apart and no claim from Skyline at that point. And the bankruptcy proceedings, Your Honor, had no tolling effect in this case because although Skyline claims that it was an assignee of the church, it really, in the adversary proceedings, it wasn't. It was in different, in adversarial positions. And also,
Counsel, I'm sorry, just because you're talking about assignments, just before you run out of time, can I take you back to the second ground on which the district court dismissed the JPA claim? So you said, if I understand right, look, everybody knows you can't assign claims under that statute. But I think, if I'm understanding right, what they're saying, your colleague is saying, is that's not what happened. Nobody assigned a claim under the statute. They assigned the insurance proceeds, as you were just discussing in connection with the bankruptcy question. They assigned the insurance proceeds, and then we, Skyline ourselves, tried to get those insurance proceeds paid. The mutual insurance company owe us the same duty that you would anyone who was insured by you. So what's the problem?
But Your Honor, that's the very problem. There's no privity of contract between Church Mutual and Skyline. The only way that Skyline is able to assert such a claim is because of the assignment of benefits. And that brings me to another issue. That assignment is actually not even valid because it was done without the written consent of the insurance company.
Okay, but if we assume that it was valid, I just want to make sure I understand. So we would end up with this law that sort of aggressively polices insurance company misconduct and say that only applies, that never applies when insurance proceeds have been assigned to somebody else. Once the insurance proceeds get assigned, insurance companies can do whatever they want to the new holders, the new beneficiaries. Just because they're third parties, they weren't originally insured. At this point, none of the protections of UDPA apply anymore. That just seems odd to me because aren't insurance proceeds very regularly assigned?
But Your Honor, yes, they are, but they have different remedies, and it's not under Unfair Claims Practices Act. It's they could file a bad faith claim, or they could have other remedies in the law. At the law, they don't have that particular one, which you would have to be in privity of contract to be able to assert that. And Champerty.
Counsel, if there were already a judgment here, if a court had already said that the church was covered and the policy should be paid, and then there was an assignment, and I realize that's not what's going on here, but would Skyline then have the necessary privity to be able to bring this sort of claim? In that case, are they more like a kind of a motorist who's hit by someone with insurance, and so they're kind of an intended beneficiary, or would that bring them within the privity?
I would say it wouldn't under the North Carolina law because that would still be an assignment, and under the applicable law, Champathy precludes finding assignment of such claims, tort claims. So I would still say the answer would be no, Your Honor. And I see my time has run up. If there are any questions.
Thank you so much, Counsel. Thank you.
Thank you very much, Your Honors.
Yes, indeed. Mr. Coates, you have some time reserved.
Oh, sorry about that. I think, Your Honor, if the General Assembly had intended to reduce the rights of policyholders to have their statute of limitations for breach of insurance contracts reduced further than fire insurance policies, they would have been explicitly and would have done so within 58-44-16 or elsewhere. I mean, 58-44 16E says that if the statute is more liberal than the policy, the statute prevails, which correlates to how things are construed. And to Your Honor's point about how kind of all ties go to the insured and not the insurance company. And so, if Your Honor looks at Your Honors look at the insurance policy, you know. Endorsement A100, the first thing is in the insurance policy says, you know, you've got to sue us within 2 years of the date of physical loss. And they changed that by endorsement to 3 years in endorsement A188. But you can understand that it's a slippery slope. And so if the intent of the insurance company is to restrict the rights of the insuring public by reducing their statute of limitations, I think that is a very troubling thing. And there's all the cases, again, there's no state Supreme Court case on point. The F&D Aetna case says, you know, that 58-3-35, that predecessor, you can't reduce the statute of limitations against an insurance company. That's void against public policy. We know the state Supreme Court said that. We know the Marshburn case and the Page case from the State Court of Appeals talk about homeowners insurance policies, where everything is encapsulated in kind of the same insuring agreement, and that the Quillen case did the same thing. We have not had any case, certainly no state Supreme Court case, address the issue of a commercial multi-peril policy. Again, a 190-page policy, a panoply of risks associated with that, in 3 pages, a standalone fire insurance policy on pages 120 to 122 of the appendix. That is a standalone insurance policy. It doesn't mean it can grab hold and dominate the whole 190 pages and say every risk you've got to sue from the date of loss, even though the breach might occur 2 years later. I think that's unfair to the consuming public, and I think contrary to what the rules of construction are in North Carolina, and contrary to the intent of the General Assembly. And basically, I know Judge Harris, you talked about the unfair and deceptive trade practice statute, and unfair claim settlement practice statute 58-6311, which correlates to the unfair and deceptive trade practice statute. Again, that's a 4-year statute of limitations. The Marshburn case and the Page case says that's separate. Those claims are viable, not barred by the statute. And I do think that it's different in the cases cited by Church Mutual, that when you are, in essence, Church Mutual, Skyline and the church are aligned. It's not like a liability claim. It's a property claim for work that was done. Everyone knows the work was done. It's not like I'm in an auto accident and I'm sued by somebody and I sign some claim to them for bad faith. That's a personal tort. That's separate and apart. And that's not what the unfair and deceptive trade practice statute applies, and that 4-year statute of limitation applies. And again, I also think that when you're dealing with other risks outside of insurance, you run the risk of there being latent damages. You discover that this flood or this wind has weakened the retaining wall and it's going to fall over 2.5 years later. And so I think the fire risk, the prospect from other perils of latent damage and you're telling the consuming public about, well, I hope you discover that within 3 years. If not, you're out of luck. And even though there's not been a breach of the contract, I think that is unfair to the consuming public, and it's not what was intended by the General Assembly by enacting that statute restricted to fire insurance policies.
And it's 100% clear to you, counsel, that inception of the loss, if there were a latent damage and it shows up 3 years later, your walls fall down because they were destabilized by a high wind, that the statute of limitations would not start running when the loss occurs, which is the walls falling down?
That's not how I read the language in the church mutual policy, the date that the physical damage, and there's a whole host of cases about trigger coverage from North Carolina about when the wall starts to weaken and this, that, and the other. And it's the date that physical loss occurs, I think corresponds to that hurricane, or you discover mold or mold develops and you don't discover it for a while. They're saying it's not the date of discovery. It's the date when that.
I understand, not the date of discovery. That would be when you realize that your walls fell down.
Yes, Your Honor.
Say you were on vacation and you came home, and right, you wouldn't argue about the date of discovery. You would, but it's just not as completely obvious to me as I think it maybe is to you that the date of the loss at least in some of these latent cases wouldn't actually be when the sort of latent damage manifests. That's when there's a loss. Until then, your walls were fine. But it doesn't matter. I take your point, and it doesn't matter. I don't want to hold you up.
No, I'm out of time, and you'd be surprised, Your Honor, what's not obvious to me. So,
Okay.
but I think I'm out of time unless anyone has any particular questions. If not, thank you very much, and happy first day of fall to the panel and the council.
Well, counsel, thank you both very much for your arguments and your help to the court. We appreciate it very much. We'd love to be able to come down and shake your hands. We cannot, but nonetheless, we really appreciate that. And we thank you, and we hope that you'll be safe and stay well. Thank you, counsel.
Thank you, Your Honors.
We'll proceed to our third case. Mr. Ramey?
Good morning. May it please the court. Ansel Ramey on behalf of the appellant, Constellium Rolled Products. In this case, we've alleged several errors that the district court erred by failing to independently rule on the issues of claim and issue preclusion, that the arbitrator manifestly disregarded the law by failing to apply the principles of res judicata and collateral estoppel, that the arbitrator made a clear misstatement of undisputed historical facts. He ignored the incorporation of this court's Barton decision in the 2017 collective bargaining agreement, violated public policy that's inherent in principles of res judicata and collateral estoppel, and misinterpreted the applicable contract documents. The union correctly argues that the scope of judicial review of an arbitrator's decision is fairly circumspect. But this court's precedent makes clear that relative to issues of res judicata and collateral estoppel, that those are perfectly appropriate for judicial review of an arbitrator's award. That comes out of the Wachovia case. In the Long John Silver's case.
Counsel, yes. Can I just ask you a question? Because I want to make sure I understand your position. Are you arguing that the district court erred back at the preliminary injunction stage in sending this matter to an arbitrator in the first instance, that the district court held, right, preclusion is a procedural gateway issue under Howsam, that goes to the arbitrator. Are you saying that was wrong? Or are you saying, no, that was fine, but at this point, federal court should nevertheless sort of review the preclusion holding de novo?
Yes, we are not asserting as error the reference of the threshold issues of claim and issue preclusion to the arbitrator. That's not our assignment.
Well, then why on earth, if everyone agrees that's a question for the arbitrator, I don't understand your argument that now we should act as though it wasn't an issue for the arbitrator and review it de novo, or fully, or independently, or whatever you're saying.
Right, because after the arbitrator makes the decision under the Wachovia case and the Long John Silver's case and cases throughout the country, the arbitrator's decision is still reviewed for manifest disregard of the law.
Okay.
So what happens once it goes to the arbitrator?
So you're saying we should review this under the normal manifest disregard standard?
That's correct, Your Honor. My only independent fault of the district court is that in applying that standard, which is the standard this court is going to apply and which standard the district court applied, the district court and this court is going to have to make an independent evaluation under a de novo standard of review. Do the doctrines of res judicata and or collateral estoppel
I don't know.
apply?
I literally don't understand what you're talking about. If we're reviewing under the manifest disregard standard, how is that consistent with doing de novo review? I just don't understand what you're, but I'm sorry, I don't mean, let me give you a chance to explain.
Sure. In the Long John Silver's case, the court held that the legal principle is clearly defined and not subject to reasonable debate, but the arbitrator refused to heed that principle. And here the arbitrator, from our perspective, manifestly disregarded the law in several specifics. He was aware of the law of res judicata and collateral estoppel because both parties briefed that extensively to the arbitrator. The arbitrator acknowledged that the application was an issue in the case. He indicated, if you read his decision, that he understood the law correctly. And indeed, he said, if those, at least res judicata applies, he never really engaged in any analysis of collateral estoppel. But if res judicata applies, then the grievance is barred. But he chose to ignore this court's decision in Barton, which is a manifest disregard of the law. We do not dispute that a federal court and this court is not free to overrule an arbitrator's decision, right? But it's also equally true from our perspective that an arbitrator is not free to overrule this court's decision. And it's our position that one cannot hold up the arbitrator's decision and this court's decision in Barton and reach any other conclusion other than they're irreconcilably conflicting. The arbitrator on page 173 of the joint appendix said, the union specifically alleged that the company violated the ERISA and the LMRA, with these claims resting on the allegation that retirees had a vested right to retiree health benefit. In this litigation, the arbitrator states, the union did not bring any claim based on whether the company's actions violated the party's collective bargaining agreement or other such contract interpretation claim. That's just manifestly wrong. On page 84 of the joint appendix, the first amended complaint and jury demand in the Barton class action, it is captioned, first amended complaint for breach of contract. Paragraph 3 of that complaint, which appears on page 85 of the joint appendix, says the successive labor agreements contain provisions which establish Consortium's obligation to provide retiree medical benefits throughout retirement at no cost. Despite these contractual provisions, as well as other promises, Constellium unilaterally reduced coverage for class members. In count 1 of that complaint, the effective complaint in the Barton class action litigation, count 1 is captioned a violation of collective bargaining agreements. It was an action for breach of contract. In the relief requested, which appears on page 96 of the joint appendix, they requested.
So counsel,
yes,
counsel.
Yes, Judge.
I believe what you're describing here is that you think the arbitrator misread the law. You believe the arbitrator misread Barton and misapplied it. But that is not the standard we apply, is it? The standard is manifest disregard, although that's nowhere in the FAA, but we talk about manifest disregard of the law, not misapplication. Arbitrators may get our law wrong, but I don't see that we are given the opportunity to review that and say, no, what we meant in this previous case was something different. You got the law wrong. The arbitrator acknowledged the law, attempted to interpret it, and you think he interpreted it incorrectly.
Yeah, the standard is that he in the Long John Silver's case, that he was, in making his ruling, he was aware of the law, understood it correctly, found it applicable, and yet chose to ignore it in propounding his decision. And that's our argument. And the only way you can do that manifest disregard analysis is to analyze the arbitrator's decision in light of this court's decision in Barton. And if you do that, it's clear. If you look at the Barton decision, which appears on page 77 of the joint appendix, this court stated, each individual class member retired during the operation of one of 7 CBAs between the union and one of Constellium's predecessors. Article 8 of each CBA, which appears in substantially the same form across all 7, contain a provision for group health insurance benefits. And the court talks about what all of those CBAs, and it's important for your analysis, all the relevant language is unchanged in the 2017 CBA before you. And then the court goes on, the booklet to which Article 15 refers, entitled Retiree Employees Group Insurance Program, serves as a summary plan description, SPD, of the group health insurance benefits. Substantially identical language appeared in the previous editions of the SPD. Again, those provisions are unchanged in the case that was before the arbitrator. In addition to the various editions of Article 15 of the CBA and the SPD, the union and Constellium's predecessor in another set of documents, which the parties call cap letters, to further parameters governing health benefits. And the court said, the arbitrator finds, well, wait a minute, this is the first time any court has considered whether or not unilaterally changing retiree health benefits constitutes a breach of contract. This court's opinion defines what the Barton class action plaintiffs argued to you on page 78 of the joint appendix. The retirees argue that the parties intended Article 15 health benefits to vest and to continue beyond the duration of the CBA. Accordingly, they contend Constellium's unilateral alteration of those benefits breached its obligations under the CBA. And the court concluded the plain language of the CBA and the SPD clearly indicates that the retiree health benefits were not vested. Well, let's look what the arbitrator did with that on page 174 of the joint appendix. The language referring to the retiree health benefits in Article 15 of the 2017 agreement was left unchanged. He acknowledges that. The 2005 SPD issued by the company was also left unchanged. And finally, the 2017 cap letter was updated from previous versions, but it also contains certain language like the language of Article 15 of the 2017 agreement that remains largely unchanged. Specifically, the only change to the cap letter that was before this court was a change to increase the monthly supplement for future retirees, no past retirees. So the arbitrator takes all of this and essentially overrules this court's decision in Barton. And from our perspective, that meets the manifest disregard standard. We cite cases from Third Circuit and other courts in which, under similar circumstances, and I would certainly agree with the union in this regard. If we were only arguing that somehow the arbitrator misconstrued or misapplied the law relative to some general issues of law, it would be a different argument. We're talking about threshold issues of res judicata and collateral estoppel. And under those circumstances, it's our argument that it's clear. And it was a manifest disregard of the law for the arbitrator not to apply the principles of res judicata and collateral estoppel to bar the claims. In the union's
counsel,
briefing,
counsel, sorry. So, this isn't a case. Am I understanding this right? Nobody here is arguing that the arbitrator doesn't have to give preclusive effect to federal court judgments, right? The arbitrator says, giving preclusive effect, if that is what is required under res judicata. I mean, I guess what I'm saying is there does seem to be sort of a threshold question, like maybe arbitrators don't have to apply res judicata and collateral estoppel to federal court judgments, but that's not what is at issue here. Everybody agrees those doctrines apply. The arbitrator purported to apply them, applied them to the facts of the case, and you think the arbitrator got it wrong. And I guess I'm not understanding why you, if so, why you think there's something special about that legal question as opposed to other legal questions.
Well, because this gets into the public policy argument. What occurred here from Constellium's perspective is it litigates this issue about when rights of retirees vest in health benefits. And the court determined they vest in the CBA in effect at the time of the retirement and don't continue past that, and can be changed unilaterally by the company. Constellium prevails on that, and so a year later, it issues a letter pursuant to this court's decision in Barton saying we're going to unilaterally change the retiree benefits who retired under previous CBAs, as this court said we can do. And that goes to the arbitrator, and the final test under Wachovia and Long John Silver's is that the arbitrator chose to ignore a law that he, in this case, the law of res judicata and collateral estoppel, that he was aware of, he understood, found applicable, but just chose to ignore. And as I acknowledged from the beginning, it's a very high standard we have. But unless courts are going to enforce their judgments, the other thing you have to realize, what this sort of leaves, if it's untouched, is the union's argument is, well, there's a reset every time there's a new CBA. The current CBA ends in 2022. Well, during that 5-year period of the CBA, there could have been other arbitrations and other arbitrator awards. If you take what the arbitrator has done and the district court has affirmed to its logical conclusion, well, none of those rulings are res judicata. No court cases that were decided during that CBA are res judicata. We'll just start all over again with the new 2022 CBA. We think that's untenable. We don't think that's what the law applies. And therefore, we ask that you either remand to the district court with directions to analyze the issues of res judicata and collateral estoppel, or with an order that the arbitrator's award be vacated. Thank you very much.
Thank you, Mr. Raymond. Mr. Sharma?
Thank you, Your Honor. Okay, timer is just reset. I'm Anish Sharma. May it please the court, I represent the steelworkers in this matter. I have to say, I'm going to change my outline a little bit based on Mr. Ramey's comments made here. Is a little bit different than I expected him to make. He concedes that this issue is governed by the limited standard of review that applies to arbitration awards. And he concedes that the question of preclusion is a threshold issue that's for the arbitrator to decide. That really decides the case here. Once the issue is submitted for the arbitrator to decide, and the court applies its limited standard of review, it cannot get into the merits. Somehow, Mr. Ramey argues that under the manifest disregard standard, the company is still entitled to de novo review of its preclusion argument. That's not how the manifest disregard argument standard works. In fact, this court has specifically said that it's not an invitation to get into the merits of the grievance or the arbitration. And he points to the Long John Silver standard. But that standard says that the arbitrator has to be aware of the law, understood it correctly, found it applicable to the case before him, and yet chose to ignore it in propounding his decision. And then it talks about knowingly ignoring the law. The arbitrator here clearly analyzed the issue. He evaluated the two parties' positions on the res judicata and collateral estoppel questions, and he offered his conclusion to that. And he found res judicata did not meet the elements that the elements weren't met for res judicata to apply. He didn't knowingly ignore that it would apply. He clearly, by analyzing the issue, conceded that had the elements been met, that would apply here. He found in his analysis the elements don't apply. And that is enough for this court to affirm. He did his job as he's required to do. I don't know how the court is allowed to engage in de novo review here. I didn't quite understand Mr. Ramey's argument as to why this would be treated differently than any other procedural arbitrability issue that gets submitted to the arbitrator. There's none that I know of, a procedural arbitrability issue that gets submitted to an arbitrator in the first instance, that this court would then have the opportunity to review de novo. It wouldn't make a whole lot of sense to require that procedure. Say, parties, you need to submit this question to the arbitrator first. But ultimately, it's us, the court, who have the ultimate authority to decide that issue. That would be sort of an inefficient issue, a procedure, which would undercut the whole purpose of arbitration, which is supposed to be an efficient conclusion of these disputes. Also, engaging in such a de novo review at this point could also undercut the parties' agreement as to how what issues would be arbitrated. The arbitration clause in this CBA says any differences between the parties as regard to the meaning or application of the provisions of the CBA are to be submitted to the arbitration. It's clear the parties expected issues that arise under the CBA to be arbitrated and to get a final and binding award from the arbitrator. The court not engaged in de novo review would honor that agreement.
Mr. Sharma, can I give you a hypothetical and just see, because the standard is pretty arduous because the parties decide to give things over to arbitration, then you sort of pick your venue and you have to stick with it unless you can show basically what I would call almost nullification of the law. But here's the and try to focus. Let's say it was a homeowner who had a sidewalk in front of their home, and a person came and sort of they slip and fall, and they said, we're going to sue you, but somehow they had an arbitration agreement that agreed to arbitrate that issue. And the law clearly says in that state that homeowners are not liable to third parties for accidents on the sidewalks. That's the law of the state, but they arbitrated. So the facts are clearly, this was a passerby, it happened on the sidewalk. And then the arbitrator said, well, no, I find that there is liability here. Because I think Mr. Ramey is saying that the facts are the same. That's why he read them meticulously. The facts are the same, they're the same parties, and sort of why wouldn't that law? So put that together, the hypothetical in sort of the framework. You mean we could say, arbitrator, you ignored the law because you're given a decision where the tortfeasor homeowner is liable for this when the law says this. We look at that and say, we can determine from your finding that but he never said, or she never said, the arbitrator never said, I'm ignoring state law. They just sort of said, I just see under these circumstances, I just think you should be, because you knew that tree root was coming up and you should have known it, and you knew about it, and you ignored it, that was a hazard. I find you should be liable. In that sense, do we have to stand by the arbitrators and say, because, well, you didn't say you ignored it, you did talk about the law, but you said that general law didn't apply here because the tree root was so obvious?
Your Honor, I think it sort of depends on in the hypothetical what the arbitrator is saying. If the arbitrator is saying, I understand that law is there, but in my analysis, I don't think it's applicable here. That's
because the tree root is so obviously uprooted, and you should have known that. That's the basis for it. Recognize the general law that there's no liability to the third party, but says, no, because that tree was just 12 inches above the grade of the sidewalk, that was just so, and that overrides what otherwise would be the general law of no liability. So she would have recognized the law, grappled with it, found circumstances to rule otherwise. You mean we have to say, oh, that's fine, notwithstanding a clear, comprehensive law that says no liability?
Yeah, unfortunately, Your Honor, I do believe if that's the circumstance, there's sort of two different ways that the arbitrator could answer it. It answers it, and I believe that your hypothetical is that the arbitrator analyzes the law and says, under my understanding of the law, it does not apply in this situation. Versus, I simply don't, I understand that law is there, but I don't think it binds me. Let's say it's the first one, they say, I analyzed the law, I've looked at the facts of this case, my understanding of the law is that it does not apply in this situation. I do believe that this court would have to defer to that because the standard has been very well articulated. You don't look to legal error. You don't look to see if there's serious error on the part of the arbitrator. You simply look to see if the arbitrator did his job or not. And I believe it's in the Wachovia case, this court specifically says that when the parties agree to arbitrate these disputes, they run the risk of the arbitrator disagreeing with the way they understand the law to work. And that's part of the idea here is that we've entered into an agreement for an alternative dispute resolution system in which an arbitrator offers a quicker decision. In the labor context, oftentimes the idea is the arbitrator understands the workplace better. So they have a knowledge that they bring to these disputes that the parties want. But one of the risks you run is that you get an arbitrator who might get things wrong. But in agreeing to arbitrate that dispute and agreeing to not have a dispute like that taken to court, that's one of the risks you run. And I want to say that that's a little bit of what you see, and there's these other decisions. It's the John Morrell decision, for instance, where the Eighth Circuit says that this is an issue for the arbitrator to decide, the exclusive effect of the prior judicial decision. And then they say, and then that's reviewed under the limited standard of review. But in that decision, the arbitrator simply said, I'm not bound by res judicata, collateral estoppel, because this was dealt with a prior jury award. And he said, well, I don't know sort of what the jury instructions were. I don't know what the basis of the jury's award was. I don't know any of that. So I'm not going to be bound by res judicata here. And the court did vacate that because that's the difference between the idea of our case and sort of where a court could vacate is that in our case, the arbitrator didn't ignore it. He understood that res judicata and collateral estoppel were issues in this case. He lists them as issues that need to be decided. And he analyzes it and he provides his answer to that question. And that's enough for the court to stand down on reviewing the merits of his decision. He did his job, he provided his determination, and that's what the parties have bargained for. And that's what the court needs to let stand. Now, I will say, just because you mentioned it, that you say it's the same facts here. That's what Mr. Ramey is arguing. And they do argue that this is the same facts, same transaction. But I want to raise that the unilateral changes that prompted the grievance in 2018 occurred a year and a half after the Barton decision was issued. And this court has been clear that res judicata does not apply to a cause of action based on events that occurred after the prior litigation. In Ohio Valley Environmental Coalition versus Aracoma Coal Company, I'm going to give you the citation because it's not recent. It's 556 F3rd 177. The court explained that the fact that two suits that involve challenges to very similar courses of conduct doesn't matter for res judicata purposes. That prior judgment cannot be given the effect of extinguishing claims which did not even then exist. So it's not the same facts. The Barton was based on unilateral changes that occurred in 2013. Those unilateral changes being the freezing of the Medicare reimbursement premium that the company was offering at the time, and the extension of the cap letter to pre-2003 retirees. And the unilateral changes that prompted the union's grievance were announced in 2018. And that was the total elimination of group insurance coverage for the affected retirees, to be replaced by an offer of $4,500 in HRA to go purchase their own individual Medicare Advantage coverage. So completely different, unconnected events, and the second set not having occurred at the time that Barton was decided, therefore they could not have been brought within that litigation. As long as I'm on that point, they couldn't have been brought in that, the claim couldn't have been brought, the legal claim couldn't have been brought in Barton anyway, because it would have been subject to the arbitration agreement of the CBA that was in place at that time. The company has raised a number of other bases for vacating the award. None of those meet standard, and we submitted that on briefs. If anybody, if there aren't any more questions on any of those, or if any of the judges have any more questions for me, I think I'll just rest on my briefing then on those other issues.
Thank you so very much, Councilman. Mr. Rainey, you have some time reserved.
Thank you, Your Honor. One of the cases we rely on is the New Jersey Bell case. And in that case, the Third Circuit recognized, as we've conceded, the merits of an arbitral award are not subject to plenary review by a court. But the Third Circuit was careful to say, quote, the court may examine the grounds upon which the arbitrator rested his or her decision in order to ensure those grounds are appropriate. Specifically, quote, when a federal court is presented with the contention that a prior federal judgment determined issues sought to be relitigated in an arbitral forum, it must first determine the effect of the judgment. And that's all we're asking this court. We're not asking this court to conduct anything other than the Third Circuit did. We also cite the American Train Dispatchers case from the DC court. Quote, courts have the right of plenary review when asked to determine the preclusive effects of a federal judgment on relitigation of the same issues in an arbitral forum. And that's what we have here.
Counsel, those cases don't apply the manifest injustice standard. They say they're not doing that. They're applying plenary review. The manifest injustice standard does not apply. The first thing you said to us today was that you're not arguing for that. We're under the manifest injustice standard. So honestly, what is happening here?
Well, those cases, from our perspective, are, even though they don't say they're applying the manifest injustice standard, are essentially doing it. As a practical matter, that's what they're doing. They are taking a look at an arbitrator's acknowledgement of a prior decision, having the issue raised of either collateral estoppel, res judicata, or both, acknowledging that it applies, and then just blatantly ignoring it, effectively overruling the federal court that entered the judgment. And it's our view that federal courts, including this court, have the right to vacate a judgment in that regard. One argument that was made by the union was somehow that the arbitrator was enforcing the CBA. The CBA, by its terms, states that the Constellium recognizes the union as the exclusive bargaining agent for its employees. It defines what the term employees are. In Article 15, it specifies that the provisions related to retirement benefits only apply to retirees under the 2017 CBA, not prior employees. And the 2005 SPD, which this court interpreted in Barton, specifically says that it does not apply to past retirees. It only applies to employees. And also states, quote, The company reserves the right to change or terminate its plan at any time for any reason with regard to current, past, or future employees, retirees, and beneficiaries. This document is not a promise to always provide any particular compensation or benefit. So when the argument is made, all the arbitrator was doing was enforcing the CBA. I just read you the provisions. He's manifestly not doing that. And again, we're only asking, this court to enforce its decision in Barton, and not to second guess the arbitrator. I mean, not to overrule him just as a matter of law, but on these threshold issues of res judicata and collateral estoppel. Thank you very much.
Thank you so much, counsel. Thank you for your arguments both, and we appreciate it very much. We can't reach you like we would normally, but know that we much appreciate it and wish you well, and you'll be safe. Thank you.
Thank you.
We'll proceed to our last case for this session.
Thank you, Your Honor, and may it please the court. Michael Lieberman on behalf of the petitioner. This case presents
sir, excuse me. Sorry, Judge Gregory. Ms. Bruckner has not unmuted yet. I don't know that she's back, so I'm going to have to give her a call on the phone. So please stand by.
All right. Thank you. Glad to have you with us. All right.
Thank you.
Mr. Lieberman, you may start.
Thank you, Your Honor. May it please the court. This case presents several substantive and procedural questions regarding the reasonable fear screening process. I'd like to start, if I may, with what I think is the simplest and most straightforward way to resolve the case, and that would be to rule on the merits that my client has demonstrated a reasonable fear and is entitled to get past this screening process and onto a full withholding of removal hearing, which of course is the only relief we're asking for at this point, just access to the hearing itself. I say that's the simplest and most straightforward way to resolve the case because this court has already decided several cases with very similar facts and in one case, Hernandez-Avalos, almost identical facts in which the applicant has been threatened with death or attacked, or both, as in this case, on account of their family relationships because of who they're related to. And in all of those cases, this court has repeatedly reversed the board or reversed immigration judges for misapplying the nexus requirement and not recognizing both that a family is a particular social group for purposes of the immigration statutes, and that when someone is persecuted because of that family relationship, that satisfies the nexus requirement. I think this case is actually a lot easier than a lot of the cases this court has already decided, because a lot of this court's prior cases have kind of a mixed motive thing going on. For example, in one case, a gang was extorting one person, that person left town, and the gang started extorting that person's daughter. And so you have this question, is this just an extortion case, just a greed motive, which wouldn't be protected, or is it a family motive because they're extorting someone within the same family? I think that's a hard case, but even in that case, this court held that the family motive was a central reason for the persecution, and that was enough to satisfy the nexus requirement. Here, it's a lot easier. Yeah.
Counsel, can I ask you a question? Just assume hypothetically that I agree with you that the agency was wrong and can't be reconciled with Hernandez Avalos on this nexus to a particular social group question. So, and even that I agree that on this record, there was past persecution, and that's clear under our precedent. Wouldn't the more typical thing we would do then be just on sort of the ordinary remand rule, correct that error, send it back, and let the IJ figure out what follows from that, whether she still thinks it's worth looking at relocation, whether maybe the burden has shifted on relocation? I mean, isn't it typical that we would just send it back and let the IJ take it from there once we've corrected this clear error?
Sure. I mean, this court has approached that question both ways. I mean, it usually happens. This court has more cases in the asylum context, in the straight up withholding context, but it has done both things. We filed a 28-J letter on Hernandez Cartagena, and in that case, this court just reversed straight up instead of sending it back. So I think that's an option. I don't think it's the right option here, because I think, as you just suggested, or at least you want me to assume, the persecution question is clear. And then on the relocation question, I think, that's something that is a legal error. I think it's actually two legal errors for the immigration judge to have ruled that relocation was a ground to deny the claim here. I mean, I'll explain why. I think, as we say in our brief, relocation really is not part of the reasonable fear inquiry. The way we know that is just by looking at the regulations. If you look at the withholding of removal regulation.
Counsel, I have a question. I have a question about that.
Sure.
You're of course right that 1208.31 doesn't mention relocation. And 1208.30, I understand, is different. That's expedited removal. But that points us to 208.30, which, again, I understand is expedited removal. But it also discusses the reasonable possibility standard. And in describing what should be considered in assessing whether there's a reasonable possibility of persecution or a reasonable possibility of torture, 208.30 says one of the factors you consider is whether the applicant can relocate. And I'm struggling to understand the import of that, and whether we should take that into consideration or how that factors into our analysis here. Can you tell me your position on that? I don't think the parties discussed 208.30, but it lays out what should be considered when someone's considering whether there's a reasonable possibility of persecution or torture.
Sure, Your Honor. I don't have that regulation in front of me, but if it's the expedited removal regulation, the standard there is credible fear. It's actually a different standard.
Well, no, it's not. It's the standard for asylum is credible fear, and then the standard that the regulation is talking about for persecution, for withholding, or for torture is the same. It's the reasonable possibility of persecution. It's the same language, but of course that I understand that the relocation factor is not repeated in the regulations that you're talking about. But what, if anything, do I do with the factors that are laid out in 208.30?
So I think I would say two things about that. First, the fact that it's in 208.30 and it's not in 208.31, I think we have to view that as an intentional omission and not read it into .31, which is where we are now. And so I don't think there's license to kind of assume it also applies there. I think it would actually be the opposite inference, that it wouldn't apply there. And the second thing is, I think it's important to keep in mind what this reasonable fear screening process is. It's a screening process. The idea is to save the time and resources of the immigration judges and of the board by filtering out frivolous cases. And you know, the last thing you want to do when you're setting up a screening process is make that screening process just as detailed and just as complex as the process you're screening for.
Counsel, I understand your argument, but it's not like the IJ or the asylum officer were going rogue here. I mean, the agency manual says you consider relocation. It imports the whole burden shifting regime from the withholding regulation. The checklist, the agency checklist that the AO was using says you consider relocation. I mean, do you want us to enjoin all of that as contrary to what, the regulation? I mean, you say you're not bringing a facial challenge, but the agency clearly has construed its own regulation so that you do look at relocation. And I'm sort of, and it doesn't seem obvious to me that you wouldn't. This is inherently a forward-looking inquiry. Would the person be persecuted upon return to this country? So what do you want us to do, I guess? If the agency has construed its regulation and is actually telling its AOs that they have to look at relocation, do you want us to enjoin that agency guidance?
No, and I actually disagree with the premise of the question there. I mean, I think if I'm looking at the administrative record at pages 138 to 140, this is the kind of the form that the asylum officer fills out, the record of determination, and it doesn't mention reasonable fear anywhere. Or excuse me, it doesn't mention relocation anywhere. There are sections for credibility and reasonable fear, but relocation is not something, there's no box to check with that being the basis for denying the claim.
Wait, on page 67, or do I have the wrong form at the top of page 67? Whether it would be reasonable for the applicant to relocate within the country to avoid future persecution? No?
Yeah, I'm looking at
if I'm looking at the
138.
wrong form, I apologize.
No, that's okay. I'm on page 138, which is the actual kind of the final determination, the final record of determination that gets sent out to the immigration judge, and that doesn't have any spot for relocation. I mean, I think.
Okay. Well, on page, I'm looking at the reasonable fear determination checklist and written analysis, and at the bottom of 66 through to the top of page 67, it does say, can the applicant relocate? And that's consistent with the agency manual that you cited. Which, you know, and I think this cuts both ways. It also makes very clear that you look at relocation, but you employ the same burden shifting regime as under the withholding regulation, so that the burden in this case would be on the government. So I'm not sure who benefits more from this agency guidance, but it is what it is.
Yes, thank you, Judge Harris. You've anticipated my response, which is that, you know, I think that this form isn't consistent with the regulation itself, and so I do think that's a problem. But as you say, even if the relocation inquiry from the withholding stage does apply at the reasonable fear stage, it has to apply the way it is. And the way it is, when there is past persecution, as there is here, the burden to prove that relocation would be possible and reasonable is on the government's burden. And here, as a matter of law, the government could not have satisfied that burden because the government didn't introduce any evidence in this proceeding. At the asylum officer interview, the government isn't present. And then at the hearing before the immigration judge, that government was there, but didn't introduce any evidence, didn't say anything, and didn't give any kind of basis on which to hold that the government has satisfied its burden. Now, I think the fact that the government's not at the interview and the government usually doesn't introduce evidence at one of these hearings is a good indication that relocation just isn't supposed to be part of this inquiry, because it would never really be able to satisfy its burden. But I think at a bare minimum, it would mean that if the inquiry applies, we would win as a matter of law. I mean, I also think we would win on the facts here. I think we have the best possible evidence that relocation wouldn't solve the problem here, and at least at our 10% threshold at this stage, which is that when my client was erroneously removed back to Guatemala and went into hiding in Guatemala, he was still tracked down and chased down and almost killed, in his view. And so we already know that simply relocating and going into hiding is not going to solve the problem. And so I think even if this inquiry didn't have the burden shifting that it does, we would still win. But of course, we don't need this court to kind of reach that factual question. You can just rule on the law that the government hasn't satisfied its burden. I do want to also talk about the right to counsel question. Of course, if this court reverses on the merits, it does not need to reach the right to counsel question. And I also know there's been a lot of back and forth in 28J briefs over the past few days on the right to counsel question. But I do want to emphasize a couple of points. The first is that the Ninth Circuit decision we cited, the Orozco Lopez case, focuses on the statute. A lot of our back and forth in the 28Js focus on the statute. I just want to flag again that the regulation here, 8 CFR 1003.16, is even clearer than the statute. It says the alien may be represented in proceedings before an immigration judge. These were undoubtedly proceedings before an immigration judge, and so I just don't see any way there wouldn't be a right to counsel here.
Counsel, can I just see if I can focus your argument? You know, we're here on a right to counsel claim, but your client had a lawyer at the IJ hearing, was represented, the counsel filed a brief and attended. So it seems what your case is about is not a right to counsel, but a right to make a closing argument. And I'm having trouble seeing where you get that. Even if we agreed with the Ninth Circuit in its most recent decision, and we thought there was a statutory right to counsel, where are you getting the right to make a closing argument?
Sure, it's not the right to make a closing argument per se, it's the right to meaningfully assist a client and to actually do what counsel does.
Well, but the only thing you asked, the only thing that anyone asked to do at this hearing and didn't get the right to do was make a closing argument. Nobody said anything about there are other things I would like to do to meaningfully assist. The only thing that the IJ said that, you know, anyone, I mean, I don't think there even was really an objection, but the only thing anyone asked for that the IJ wouldn't give them was a right to make a closing statement.
I think the request was a right to be heard, and I'm not sure if it would, you know, if it would have gone just to a closing statement or would have gone to questioning a witness.
Well, it was at the very end. Everything was finished, and she said, "Can I say something now?" So I don't know what else it would have been.
I think it would have been a few things. It would have been an opportunity to clarify testimony by eliciting more direct testimony. I mean, obviously from the transcript, there were some communication difficulties. This is being done by video conference through a translator. And the immigration judge stated herself, she had a hard time kind of understanding what was exactly the testimony was getting at. So I think that would have helped in a lot of ways. I think being able to provide a closing argument, of course, to explain how the facts apply to the law. I mean, that is the basic stuff that lawyers do. And so if the right to counsel doesn't involve the right for counsel to make a legal argument, then I'm not sure what good it is. If an immigration judge is going to hold a hearing, and at that hearing is not going to allow the lawyer to participate, but is going to rely on the results of that hearing in order to make her decision, then the right to counsel just hasn't been honored in that way. It's almost akin to not allowing the lawyer into the room at all, because the lawyer has simply not been able to do anything to assist at that hearing.
Counsel, there's like a right to counsel in you know, under the Sixth Amendment in criminal cases, but we decide an awful lot of cases on the briefs without giving anyone a chance to make any argument at all. And so it's not that, what's right, you know, it's not immediately obvious that allowing counsel, at least to me, that allowing counsel to file a brief but not sort of speak orally sort of drains the right of all meaning. We assume in all kinds of cases that no, the brief is what really matters, and there was a brief filed here.
Your Honor, I agree that if the immigration judge wanted to decide this case just on the papers and not have any hearing at all, I don't think we would have a right to counsel claim. The problem is the immigration judge decided to hold a hearing and to base her decision on the results of that hearing, but then at that hearing did not allow my client to have his counsel. So I think that the better analogy is if, you know, this court doesn't have to grant oral argument, but if it grants oral argument, maybe in this case, for example, but then told me I had to sit down and my client had to present argument on his own behalf, I think that would violate his right to counsel. And it's the same thing here. We're holding a hearing, we're considering what happens at that hearing to make our decision, and yet we're not allowing counsel to assist in that process and assist the client who not only you know, is coming in via teleconference and not only, you know, isn't speaking English and is going through a translator, isn't familiar with our legal system, and it really is kind of in the most vulnerable position when counsel would be able to help, and not to mention the stakes here, which are that, you know, if he loses this case, he would be removed to a country where it's pretty much undisputed that he has received death threats, and he very well, you know, has certainly expressed a reasonable fear of death threats, and we think has gone far beyond that, and has made a very strong case that would ultimately win on a withholding claim that he will be persecuted, tortured, and possibly killed. And so we think, given the stakes involved, given the facts regarding his own personal circumstances, his right to counsel here just was simply violated, and counsel needed to have an opportunity to meaningfully participate in the hearing. If there are no other questions, I will reserve the rest of my time for rebuttal.
Thank you, Mr. Lieberman. Ms. Buckner.
Thank you, Chief Judge Gregory. Good morning, Your Honors. May it please the court. Petitioner had a meaningful opportunity to be heard, and his due process rights were fully satisfied. As you know, the procedures are set forth in the regulation 1208.31. This is a screening process, and the asylum officer and the immigration judge followed all the procedures. Counsel attended both the interview and the review. Evidence was submitted at both, and oral statement was made by counsel after the interview.
Counsel, I have a question about the grounds for the decision here. The IJ listed three bases. The government seems to treat the last one as kind of part of the first one, right? The difficulty articulating fears, not really an independent ground. It's just part of the IJ's assessment of the nexus, perhaps. What do we do with relocation? Is relocation an independent ground to find no reasonable fear of torture or persecution, or is it part of the overall analysis so that if we find a problem on nexus, we need to send this back because it needs to be reevaluated? I'm not sure how to read it.
Okay, I understand, Your Honor. The regulation for withholding specifically states at 1208.16b that relocation, the ability to safely relocate within the country to avoid the harm that is feared, and that it would be reasonable to do so. That is an eligibility requirement for both statutory withholding under subsection B and CAT withholding under subsection C. So when the IJ said ability to relocate, that was an independent dispositive ground for for finding no reasonable possibility of withholding and CAT withholding. It's an eligibility.
What about the burden shifting problem that Judge Harris points out, that if we think there's a problem with nexus, then he's potentially will be able to establish past persecution, and the burden would shift to the government on relocation. So what do we do with that?
Yeah, I'm not sure that our briefing was totally clear on this. I'd like to point your Honor's attention to 66 of the record, page 66, which is the reasonable fear determination checklist and written analysis. And I fleshed out in my briefing that at the very bottom, 1A, past persecution, it says the applicant established that the harm, and it goes through all of this, and it says no, that the box is checked no. So that means that there was no past persecution established.
Right, but what if we disagree with that?
Well, may I be heard on why you shouldn't disagree with that?
Well, yeah, of course. But my question first, you can of course address why we might be wrong. But if we think that there is evidence of past persecution, then what do we do with the relocation holding?
Okay, the evidence of past persecution is separate and apart from the relocation holding. It's an independent dispositive basis under the regulation. So if let's just talk about CAT. So CAT, there's no burden shifting in CAT, withholding CAT. It's always going to apply. But with statutory withholding, there is a burden shifting, but it's my understanding that the perpetrator has to be government sponsored and not a private actor, and there has to be no past persecution. So in this case, the perpetrator was the gangs. It was not the government actor. So that burden shifting does not occur.
Has anyone in the agency, to your understanding, has anyone in the agency made any finding on the prong you were just talking about, the government or the entity that the government was unable or unwilling to control? The AO didn't address it and the IJ didn't address it. So I guess I'm not clear on whether we can rely on that here.
I understand, Your Honor. Well, the AO didn't write about it in her analysis.
The AO made extremely clear what the AO was relying on, and that was not it. The AO, unlike the IJ, we have a pretty clear understanding of the AO's reasoning, and that was not it. The AO said family is not a particular social group.
That's correct, but she did check the box no for past persecution.
Well, but that just means you didn't establish everything. And we know from her written explanation that the thing she found had not been established, had nothing to do with willingness or ability. Could you just maybe assume hypothetically, and I understand you disagree, but assuming hypothetically that on this record, we can't say there was no past persecution, that would mean that now the burden shifts to the government on relocation, right?
Correct. However,
okay. And is it your position that on this record we could find under substantial evidence review that the government has met its burden of showing that this person could relocate reasonably?
Well, if we can go to subsection B, I believe this only applies when there's a public actor and not a private actor. I'm looking at this. Eligibility.
But if you just assume with me heroically, assume I've made a whole bunch of mistakes, but here I am, I think the burden has shifted on relocation. All I want to know from you, I guess, is it the government's position that if the burden has shifted on relocation, we could affirm this finding because there's substantial evidence showing that the government has met its burden of showing that this person can reasonably relocate in Guatemala? Or is the government not taking that position? That's all.
I understand, Your Honor. The government did meet its burden, I believe, because basically, based on the testimony provided, I mean, the testimony was completely vague and unresponsive, and in fact, when he was asked how he whether he would be sought after when he returned, he changed the subject before the IJ. And when he was asked, how will they know that you are Mr. Tomas Ramos, and he said, because I go to church, because I'm a Christian. I mean, there's no evidence whatsoever in the record that he would have difficulty relocating to another section of Guatemala.
Well, I read the IJ. I mean, the IJ doesn't give us much in the way of reasoning and writing, but if you read the hearing, it seems clear the theory is, he says, I can't relocate, it won't be safe, the gang will be looking for me, and I'm easy to find because I go to church. So you can just kind of hang out around the church and there's where I'll be. And she says, you're not that big a deal. You're not that notorious. Nobody cares. Bygones. Your son's already out of the country. They're not going to bother looking for you. I mean, that's the whole theory on relocation, the bygones theory of this case. The gang is not coming after you. It's not that big a deal to them. And I just don't understand how, even if the burden weren't on the government, I would have real questions about whether there is substantial evidence in this record supporting a finding that he can safely relocate, because the IJ's theory is totally contradicted by his testimony about what happened when he was deported by mistake to Guatemala in 2019. And indeed, the gang was not treating this as bygones. They were still after him, even though his son was out of the country. So I'm really struggling on relocation with what could possibly support this finding.
I think I can help there. In those 3 months when he was wrongly deported, at the end of 2019, he lived at a church member's house. That's in his own community. He didn't relocate to another section.
I'm saying something different, because the IJ, it's not as though the IJ said you could live over here. The IJ said the reason you can relocate is because they're not looking for you at all. You could go anywhere you want. They don't care anymore. Your son is out of the country. They're done with you. And that turns out not to be true. So everything we have of the IJ's reasoning is contradicted by the record. And there's nothing else in here on relocation. It's not as though the IJ said you could live with your uncle who lives in this city in Guatemala. All the IJ said for why you can relocate is they're not still looking for you.
And what the petitioner did, however, was he merged his claims. He said, I can't relocate because they'll know I'll be a Christian. Well, wherever he
But why isn't that perfectly sensible? Why isn't that so sensible? He's saying wherever I live, I go to church, I wear a unique shirt when I go to church, I carry a special Bible. How hard am I to find?
Your Honor, I was just explaining how he's merged the claims. That doesn't show that he's Welder's father and that he refused gang recruitment. So he can relocate to another part of Guatemala and they will not know that he is Welder's father who refused recruitment. When he hid in hiding, he was at the church member's house, and that was not in another part of Guatemala. When you look at the relocation requirements and case law, if he's saying I can't relocate to another part of Guatemala because I'm a Christian, the IJ said the majority of people are Christians. How are they going to target you? How are they going to target you, Mr. Tomas Ramos, because you're a Christian when everybody and when the great majority are Christians? It doesn't add up. So he's merged his two claims there. And I think it's important to differentiate them. The court's indulgence, please. As far as past persecution, if I may be heard on that, if Tomas Ramos testified exactly like his declaration was written, absolutely, he made the nexus requirement under the Fourth Circuit precedent, but he didn't. The declaration submitted before his testimony, at the IJ, was very detailed. It's the first time he mentioned harm, and it was, and he suddenly had a black eye, and his daughter had a rock thrown at her, and the wife was beaten, but he never mentioned harm before there. So I mean, I think we should take that checkbox pretty seriously. There was no past persecution in this case. When he was asked by the IJ, and where did they hit you? All he said in the IJ proceeding was that these people came to his house before he got there. They knocked down the door. He told the AO he saw blood everywhere, but somehow something happens with the gang fighting. And then he said, and they hit me. And the IJ said, and where did they hit you? And he changed the subject. I mean, he had a chance to show harm in his testimony, and he never did. He absolutely did in the declaration, but he didn't.
Was this a ground for the? Sorry, counsel. Was this a ground for the IJ's ruling? I thought the IJ said there was no nexus to any protected ground, not that there was no harm.
That's correct. Your Honor. There was no nexus, and but I think I was responding to the burden shifting. But you raised a good point. It's not in the final agency determination, the past persecution finding. So for that reason alone, I think the burden shifting does not have to be the case here.
Counsel, would you repeat what you said? You said for that reason alone, the burden shifting what?
Well, because the final agency determination is the IJ review. It's not the AO review. And as Judge Rushing pointed out, the IJ didn't rely on it. The IJ didn't say no past persecution. The IJ said internal relocation, no nexus, and difficulty articulating fear. So because past persecution wasn't the ground in the final agency determination, we don't have to get into it, and whether there was burden shifting and because it wasn't
the IJ. I mean, the nexus goes to whether there was persecution, right? My point was just the IJ didn't say, I find there's no reasonable possibility of persecution because you weren't ever harmed to begin with. The IJ didn't base it on what you were saying, that there's no harm. The IJ said there's no nexus to a protected ground. So I read that to mean, assuming there was harm, there's not a nexus to a protected ground.
That's possible. That's a very plausible reading of that. Another reading is that, and I'm sorry that these are limited proceedings and review proceedings, and we're not going on a lot here. But another reading is at the end of the IJ hearing. The IJ talks about the elements of criminality that are involved with the gangs. So another possible thing is that she found this was a matter of criminality. Perhaps with respect to with the church member who was killed. There was a church member killed, but there's no indication of the motive for that murder. So that nexus could also be a criminality nexus, which is not, of course, not a basis for finding persecution on account of protected ground.
I'm sorry to move in a different direction, but when you said that the final agency action is just the IJ order, that's all we're reviewing. What do we do then about torture, given that the IJ said absolutely nothing about torture? I had sort of wondered whether we could just assume, given that the IJ didn't say anything but affirm, that the IJ adopted the asylum officer's finding that there was no evidence of acquiescence. But you seem to be suggesting, no, we can't do that. We're limited to what the IJ said, and the IJ said nothing. So what do we do?
Well, the IJ talked about relocation, and the right makes clear that that's always an eligibility factor for CAT withholding. So like petitioner argues that why are we looking at relocation? It's not in the reasonable fear reg. No, but it's in the withholding and CAT statute. And to say let's not look at relocation is like saying let's not look at nexus for asylum. You can't do that. You have to look at the underlying eligibility requirements when determining reasonable possibility, even though it's not, a full-blown adjudication.
Counsel, I understand what you're saying about that, and I'm inclined to agree that you would be looking, it would just be sort of sensible to look at relocation when you're making this inquiry. But I did have one question. If there's been past persecution, if there's been past persecution, then the agency presumes you have a reasonable fear of future persecution. Isn't that enough to get you to reasonable possibility? What does it mean to say that it is presumed? It's so likely that we're going to presume that you have a reasonable fear of persecution, but it's still not reasonably likely that you'll be it just seems to me that I understand why you would look at relocation generally, but I'm a little I'm just wondering what you think about whether it's obvious you would still look at it if there's been past persecution, which gives rise to a presumption that your fear of reasonable persecution is a reasonable one. And if all we're asking is there a reasonable possibility, what is the space between those two things?
I understand your question, Your Honor. The internal relocation assumes you can safely and reasonably relocate to another part of Guatemala. So whether or not you had a reasonable fear of persecution in your hometown is not related to your ability to relocate where there are different gangs or no gangs, and they don't know your history. So But
if it's totally unrelated, why is there a presumption? Then it doesn't make any sense. The mere fact that you've shown past persecution in your own town would have no bearing whatsoever on whether it's likely you'll be able to relocate. But that's not what the agency thinks. The agency thinks if you were persecuted in the past in your own town, they will presume. It's so likely that we'll just presume it, that of course you'll be persecuted anywhere in this country. And now the government has to prove why that's not so. So they're obviously related.
I think they're in the same section of the regulation, but the second one, the relocation, defeats the first one. Yes, okay, if you have established past persecution, you have a reasonable fear of future persecution, but certain things make that irrelevant, including the government defeats that by saying you can relocate in another part of the country, and those gangs won't know you, and they won't know your history. So they are in the same regulation and same paragraph, but they're not logically related, except to the effect that the relocation defeats the past persecution finding. That's why they're in the same section.
Can I ask you a question? Going to the right to counsel, because I want to give you a chance to respond to what your colleague was saying toward the end of his argument. And I understood the argument to go something like this, and I'm adding only a little bit, that, look, if the IJ is acting in an appellate capacity, you might not have a right to a lawyer. Like, then sure, you can just read it on the briefs. But if the IJ is acting in a sort of first instance, first order fact-finding capacity, having a hearing, taking evidence, taking testimony, making factual findings totally separate from anything the asylum officer found, as happened here with respect to relocation, well then, of course, you would need a lawyer for that. And it seems to me that the regulations, the reasonable fear regulations themselves sort of could be read that way, that they lay out in subsection C that when the asylum officer is developing the factual record, taking testimony, making factual determinations, you have a right to a lawyer, and that lawyer does have a right to make a closing statement. And so why, if the IJ, and I understand the IJ has tons of discretion about how to do this subsection G review, but if the IJ in her discretion decides, I'm just going to be a second AO, I'm going to do exactly what the AO did, I'm going to have a hearing, I'm going to take testimony, and I'm going to make new factual findings, why wouldn't you have the same procedural protections that you get in subsection C of the regulation?
Because as you can see from the forms that the AO and the IJ use, I mean, their purpose is intended to be very different. The IJ proceeding is a review. It's just a screening process, and they're only provided.
But the IJ didn't just review here. I understand that, and totally. I've always, this seems 100% right to me, that if the IJ just wants to act as an appellate judge, just pick up the record, read the record, figure out if the AO got it right, then right, you wouldn't have a right to a lawyer. But that's not what happened here. The IJ didn't do that.
The IJ largely did the review. I think the nuance here is that, of course, even though these are limited proceedings, the petitioner has the right to testify again. So to deny the IJ even sitting in a review capacity the right to assess that that new testimony wouldn't be sound. So I think you can reconcile that it was a review proceeding, a screening process, a review, and that the IJ did review and concur with the asylum officer, and that when you see how much process that petitioner received throughout, I think the court should find that his due process rights were satisfied.
I wanted to get counsel, sorry I know you're trying to wind down, but I wanted to make sure to get the government's position on this regulation at 8 CFR 1003.16. Your colleague on the other side pointed out in their brief that they think this regulation granted a right to counsel. And I know in your brief you talk about the statute, but I didn't see you talk about this regulation. What's the government's position on whether the right to counsel in that regulation applies here?
Thank you, Your Honor. The government focuses on the word may, the discretionary word may, that an alien may be represented at proceedings before an immigration judge. Because this is a discretionary term, of course, we believe it does not establish a right to counsel in any proceedings before an IJ. It's a possibility. They may have a right, but they may not. Also, in response to petitioner's argument that our position renders Section 1362 superfluous, I would just like to add that the right under Section 1362, the statute about the right to counsel, applies more than just removal proceedings, full-blown removal proceedings under 1229A. It also has independent effect in withholding-only proceedings and asylum-only proceedings regarding the visa waiver program, because they are adversarial. They are adversarial proceedings, and that's where a right to counsel is necessary, even in those two subsets. By contrast, as clearly laid out in the regulation, the screening process is not to be an adversarial process. Therefore, it's not a removal proceeding covered under 1229A. Regardless, the opposite finding would conflict with the Supreme Court cases in Nasrallah and Guzman Chavez, which I believe we've adequately set forth in our 28J letters. I'm sorry, do I have additional time? Yes, okay.
No, you don't. No,
I don't, I'm sorry.
But I will let you go ahead. You have something further on that question or just generally close?
I was just generally going to close that.
You may, go ahead.
The court should find that Congress, in enacting the reinstatement statute, left a gap for the agency to determine the reasonable fear procedures. The statute is silent, the procedures are thorough, and the due process of petitioner was established in this case. In fact, he received more due process than he was entitled to under the regulation. Thank you, Your Honor.
Thank you so much, counsel. Mr. Lieberman, you have some time remaining.
Thank you, Your Honor. I think I'll start, if I may, with the relocation inquiry. I want to try to convince the court that, even though it wouldn't be crazy for the agency to have directed that the relocation question be part of the reasonable fear process, it also makes a lot of sense why they didn't do that and why that doesn't appear in the reasonable fear regulation. And that's for a couple of reasons. I mean, number one, this is a screening process. The relocation inquiry, we haven't really talked about the contours of it. It's a complicated inquiry. It's very individualized. It depends on the precise type of persecution being suffered, the reach of the gang or the persecutor, and how big they are, how big the country is. I mean, here we're dealing with Guatemala, which is the size of Virginia. It's not that big of a country. And also
Can I ask
other
you
factors.
Sorry, to clarify, I wanted to ask, in your briefs, it seemed to me you were only challenging relocation as whether it's a valid factor to be considered. If we conclude that it is, have you not challenged that there was substantial evidence to support the finding that your client could relocate?
I believe we have, Your Honor. We pointed out that when my client was removed back to Guatemala, he was in fact tracked down while in hiding by the gangs. And we also have a lot of evidence in the administrative record regarding the pervasiveness of gangs throughout Guatemala. This court's actually decided a case already, Perez Morales v. Barr, which is 781 Federal Appendix 192, holding that someone who was persecuted by gangs in Guatemala could not relocate to avoid that gang violence because of the pervasiveness of gangs. So I think there's plenty of evidence in the record and in this court's case law to decide that relocation question in our favor.
So you're challenging whether there was substantial evidence. Am I understanding you right, that you want to be heard on that as well?
I mean, that's our third level argument. Our first level argument is that relocation is not a factor. Our second level argument is that if it is a factor, the same burden shifting approach applies. And I don't think I heard my friend on the other side offer any argument on that point.
But there's no burden.
Actually meet their burden.
There's no burden shifting in CAT, right? When we're talking about the possibility of torture instead of the possibility of persecution, right?
So for the CAT claim, there's no burden shifting on the question of torture, on the question of relocation. But the question of relocation is just part of the totality of the circumstances test in that context. In the CAT context, it's not like if you can relocate, you lose. It considers it as part of your overall holistic analysis. So I don't even think it would doom our case there. But okay. on the main persecution claim, our main argument is the relocation doesn't apply, and if it does apply, the burden shifting approach applies. And I haven't heard the government suggest they could actually win on that burden shifting approach because they haven't actually introduced any evidence of any kind.
Just leave it. I want to make sure where you go that in the context of the screening with the asylum officer for reasonable or credible fear or reasonable basis of fear of persecution. Are you saying that relocation is really of no issue at that point?
Yes, that's right. Our position is that what the agency did is say, look, there's kind of two aspects to this once you get to the actual final withholding of removal stage. The first aspect is, can the applicant make an affirmative case? Can you show that you would be persecuted on a protected ground if you were removed and went back home? And the second piece is sort of the rebuttal case. Can the government say, well, maybe that's true, but you could relocate, or maybe that's true, but circumstances have changed since you were there last, and you're not going to face it anymore. And it was perfectly sensible for the agency to do what they did, which was say, at this reasonable fear screening stage, which we want to be quick and simple and not complicated, we're just going to focus on the affirmative case and the affirmative case alone. And we're going to deal with the rebuttal kind of case the government can put on. We're going to deal with that later once we get through the screening process and get you to a full withholding of removal proceeding. That's what we believe the agency.
It is your position further that if the government does not, at the AO level, put on anything as to relocation, it doesn't get a mulligan if it goes to the IJ and it's reviewed solely on that determination. They say, no, as we indicate, we haven't found anything, but indicate there's nexus. Then you don't get a mulligan to say now, okay, well, now I know that one is lost. Let me now go to relocation. With your position, they can't do that now?
That's correct, Your Honor. I think if the government believed it could prove relocation and that was a relevant factor, it had a chance to do something about it, and it didn't do anything about it. And so on this record, as a matter of law, we would win on the relocation question, even if it applied.
Right. Okay.
For that reason and the reasons in our brief, we ask the court to reverse or vacate.
Thank you so much, Mr. Lieberman, Ms. Bruckner. Thank you so much for your argument.
Thank you.
We didn't note the
future
as we would love to, but please know that nonetheless, we really much appreciate it and wish you well. And thank you again.
Thank you.
All right.
Thank you, Your Honor.
We'll ask the clerk of the court to adjourn this session.